Yes, but I was praying for leave, Lord, for filing a Jalpaiguri matter. Lord, this is a matter concerning, Lord, an order of demolition has been passed and the date is fixed today. So there is, Lord, a bit of urgency, Lord.
Leave granted.
I'm grateful.
My lord, with the permission of that matter, my lord,
Next week we'll.
whether I can hand over the slip, my lord, next week.
My lords, in the Manrega matter, my lords, in terms of my lord's last order, the work under Manrega was supposed to start from August 1st.
It's not started.
It's not started, my lord. I have spoken to the NREJ commissioner personally, my lords. So what he's saying is, unless we receive a communication from central government, we cannot start. It's very absurd, my lords.
Next week we'll list it one day.
My lords,
Give the
like
number.
next week, if my lords may indicate a date, then I can intimate the other side, my lords, next week.
Monday we will give you the date.
Monday. I am not there on Monday, but I'll find out. I'll send some colleague
We'll
of
tell
me.
you on what date it will come next week.
My lords, grateful, my lords.
Your Lordship, I crave leave to mention the matter of Britannia Industries Limited, wherein the judgment has been delivered by my lords. There are some typographical errors, Your Lordship. Your Lordship, we've made for convenience, Your Lordship. I've also discussed it with Mr. Amit Sharma and Mr. Khaitan. And my lord, I prepared, my lord, a small write-up as well as, my lord, indicated on a copy of the order, my lord.
A lot of mistakes, huh?
Actually, my lord, it's actually too factual. The matter was, my lord, so many transactions in the matter and so many orders. It's a 263 matter, my lord. That's right.
All right, list it to order the caption to be mentioned.
We've written it, my lord, so for my lord's convenience.
You put this in the case bundle.
I'm
Lord,
grateful.
My Lord's kind leave to mention a Group 6 matter. I know that my Lord does not have a determination now, but since in the presentation for my Lord's name was written, my Lord, this matter may be formally released by this bench so that the other bench at courtroom 8 may take up this matter. It's a very urgent matter relating to compassionate.
No, it's not required to be listed. You give the letter to the OSD, automatically we'll send the. I'll call for the case file and we'll send it.
I'm grateful, my Lord.
Original side daily list item number 1.
Lordship, I am appearing for the appellants.
In this matter, Tilok Mitra is appearing, my lord.
He's not there.
He is coming, my lord. He has not received the brief, I'm told.
My lord, I am also was supposed to pray for additional time, my lord, my lord. I have been instructed, my lord, of 1 week time, my lord, because.
All right. We have heard so and so at the request of the learned advocate appearing for the appellant. Adjourn.
Grateful. And may I file the copy of service?
Affidavit of services.
Affidavit.
Affidavit of service taken on record.
My lord.
Item number 2.
Yeah, okay.
Assessing officer held that the assessee had taken an unsecured loan of rupees 40 lakhs from Nikhil Holdings Private Limited. Milord, but I must confess to you, Lordship Milord, that he was wrong where he refused to give any cross-examination of the witness who had told this thing to him. But the tribunal has held in a different ground. But I find from the
So this Muralidhar Lahoti is the director of the Nikhil Holding.
Yes.
And his statement was recorded.
Was
saying that it's a
recorded?
shell company.
Yes.
And I'll show you, Lordship Milord, that paragraph where he has refused.
Let me take from the assessment order page. Assessment order page 2.3 at page.
Milord, 2.3 on 24th August, the assessee filed its reply and requested for cross-examination of Sri Muralidhar Lahoti, and the same was rejected by letter dated so and so. Relying upon judgments of various courts, discussed in paragraph 3.2, which is clearly states that the right of cross-examination is inalienable right. Is an inalienable right. Right of cross-examination is administrative fora, is quasi-judicial proceeding, is not an absolute right and not enjoyed upon the department authority to allow the same. Which in my submission is wrong, my lord.
In the reasons for reopening, they have referred to his statement, is it?
Yes, they have referred to the statements.
And what does the tribunal say?
The tribunal, my lord, has decided the issue that from a different perspective, if your lordship kindly takes me lord, page 51, the last line.
But so far as Nikhil holding is concerned, assessment was completed under 143.3 and 153A.
My lord, that is the point. In this case, if I may indicate, your lordship, firstly, the reasons are incorrect to the extent that my transaction was of 40 lakhs, but reasons say 50 lakhs. He relies on the statement taken in the case of search, in case of Nikhil holding, which is a part of some East India group. He doesn't provide me with a statement. I have provided all the documents, including confirmations and assessment orders. He doesn't consider any of it. Even the CIT appeal doesn't do it. When the matter comes before the tribunal, your lordship, the tribunal notices that, irrespective of the statement, in the assessment of Nikhil holding, there is no adverse view taken on this transaction. And that is the assessment made subsequent to this search in question, your lordship. And I may also indicate, your lordship, that this is becoming a trend of the department to deny cross-examination in cases where they're relying on the statement. Now, the law is that if they are relying on a statement of a person, but firstly, the law is that if a statement is made by a person, my lord, that is regarded as an evidence on the case of the deponent. It does not become a evidence in my case unless it is supported by corroborating evidence. In the case of VC Shukla, my lord, the Honorable Supreme Court has laid that down, principle down, my lord. Subsequently, they're relying on statements, not providing me with cross-examination. That is impermissible. If they're not relying on a statement, they can then deny cross-examination.
No, before the CIT appeals, you raised this ground.
And before CIT appeals, we had asked for cross-examination. We filed a lot of documents showing confirmations. Maybe by that time, the assessment order had not been available to me because my written submissions that have been reproduced, they record confirmations and income tax returns filed by Nikhil Holding. But as far as the assessment order is concerned, that reference has not been given by the CIT appeals. In fact, he doesn't consider any of my documents only.
Page 35 is the order of the CIT. There, 7.2, he has recorded the statements that he has not been given cross-examination, but still held in favor of the.
But I've referred, in fact, when the assessment order is referred to, my lord may kindly take page 32, my written submissions which have been recorded, my lord. If I may read, my lord.
And the loan was repaid in the subsequent year,
My lord.
which was also confirmed.
Yes, your lordship. The 8th line from the bottom, the reopening was also bad in law since the actual loan received was rupees 40 lakhs. The assessee also submitted that the loan was genuine, recorded in the book, shown in ITR, and evidence such as ITR, balance sheet, bank statement, loan confirmation, and assessment order of loan creditor for the same year were there, and no adverse remark was made about the loan given to the assessee. So even this fact was there before CIT appeals, my lord.
Please come. This appeal by the revenue filed under section 260 capital A of the Income Tax Act 1961 within bracket the Act is directed against the order dated October 9, 2024, passed by the Income Tax Appellate Tribunal, SMC Bench, Calcutta within bracket Tribunal in ITA number 1414/K1/2024 for the assessment year 2013-14. The revenue has raised the following substantial questions of law for consideration. Page number 4, paragraph 7A, section A, then over the page. B not required, C, H. The assessment for the year under consideration, AY 2030-14 was completed under section 147 read with section 144 capital B of the Act by order dated 15/9/2021, and an amount of rupees 40 lakhs was held to be taxable income of the assessee. The assessee carried the matter on appeal before the National Faceless Appeal Center NFAC, which was dismissed by order dated 7/6/2024. The assessee challenged the said order before the learned tribunal, which has allowed the appeal by the impugned order. Agreed by the same, the revenue are before us by way of this appeal. The factual details as set out by the learned tribunal in paragraph 6.1 of the impugned order are not in dispute. In the reasons for reopening, the assessing officer held that income chargeable to tax amounting to rupees 50 lakhs has escaped assessment. However, the case of the assessee, the consistent case of the assessee was that they had borrowed a sum of rupees 40 lakhs from Nikhil Holding Private Limited, and to establish the same, they have produced all documents and details apart from the assessment which were framed in the case of Nikhil Holding Private Limited under section 143 within bracket 3, read with section 153 capital A. Apart from that, loan confirmation was also filed by the assessee. More importantly, the tribunal noted that the assessee submitted that noted that the assessee, to establish the genuineness of the transaction, produces the books of accounts where it has been recorded, the income tax returns, balance sheet, bank statement, loan confirmation, and the assessment order of the loan creditor for the same year. And no adverse remark was made about the loan given to the assessee. Furthermore, the assessing officer rejected the objections raised by the assessee for the reopening of the assessment by merely relying upon statement of one Lahoti, who was the director of the Nikhil Holding Private Limited, and the request made by the assessee for cross-examination of the said person was denied. Apart from that, that the addition was made that the said loan which was availed by the respondent assessee was repaid back in the subsequent year, and the party has confirmed the loan via confirmation which was filed in the reassessment proceedings, and no adverse remark has been made by the assessing officer while completing the assessment. Therefore, the tribunal, in our view, rightly came to the conclusion that the reopening of the assessment was bad in law. To support the conclusion arrived at by the tribunal, several decisions have been relied upon, which we feel are not required to be reproduced in this judgment and order. As on fact, the tribunal found that the reopening was bad in law. Thus, we find no question of law, much less substantial question of law, arising for consideration of the subject. Accordingly, appeal fails dismissal.
Obliged, my lord.
Item number 3.
Yes.
May it please your lordship. This is an appeal against an order of the learned ITAT Lordship, I'm only on the imposition of cost, Lordship, which has been imposed. The order was initially passed on 27th of March, which was rectified on 5th of May. My Lord will find the order, initial order at page 55. This was, my Lord, an addition made by the ITO on under section 68 on the ground that the genuineness and the creditworthiness of the creditors could not be verified. And thereafter it was confirmed by the CIT appeals on the same ground. Lordship, the matter has been remanded back to the CIT appeals, but with imposition of this cost.
But,
This is a wrong finding.
No, this money is going for a good cause.
My Lord, I can understand, my Lord, the SSC, my Lord, had he had the opportunity, Lordship, had the money to. Some concept, my Lord, I know this is a very innocuous. Yes, yes. Yes. Judicial case service.
We'll reduce the cost.
My Lord, that
Something marginal will.
Department, you have, sir, not committing to the judicial.
This appeal has been filed by the assessee under section 260 capital A of the Income Tax Act 1961 within bracket the Act, challenging the order dated 27/3/2025 passed by the Income Tax Appellate Tribunal C Bench Kolkata within bracket Tribunal in ITA number 2289/KOL/2024 for the assessment year 2012-13. The assessee has raised the following substantial questions of law for consideration. Where are your questions?
no. Whereas 8, 9, 10 may be considered, my Lord.
Paragraph 8, 9 and 10 in page number 9. We have heard Mr. Sonsal and an advocate appearing for the appellant assessee. Though the respondent department has been served, it appears that no counsel has been nominated. Therefore, we have directed Mr. Prithu Dorial and at senior standing counsel to accept notice on behalf of the respondent department, and his appearance may be regularized and his fee bills be honored. The assessee is not aggrieved by the entirety of the impugned order passed by the learned tribunal, but only with regard to the cost of rupees 50,000 which has been imposed while remanding the matter back to the Commission of Income Tax within bracket appeals for within bracket CITA for re-adjudication. Going by the conduct of the assessee, it cannot be stated that imposition of costs was wholly unjustified. However, we feel that the assessee being an individual, no. However, we feel that the cost of rupees 50,000 is on the higher side. Accordingly, we exercise discretion and reduce the cost to rupees 7,500 payable to the West Bengal State Legal Services Authority within a period of 15 days from the date of receipt of the server copy of this order. Upon obtaining a receipt for such payment, if the same is produced before the CITA, the appeal shall be re-adjudicated by the CITA after affording an opportunity of hearing to the appellant assessee or their authorized representative, appellant assessee through their authorized representative, either in person or by way of a virtual hearing. In the light of the above, we find no substantial questions of law arise for consideration, and the appeal stands disposed of with the above direction.
Grateful, my Lord. My Lord, may I find my notice of motion and the affidavit of service?
Affidavit of service taken on record.
Grateful, my Lord.
Income tax appeal letter number 4.
The last occasion, my lord directed to bring written instruction. This is the instruction I received. Not very clarified instruction.
We are showed by way of a table.
ওটা তো দেয়াই ছিল।
This table we had shown for clarity, my lord. Yes, my lord. 263 order in the middle table. Well, after the 263 order, my lord, on the left hand side, we appealed to ITAT for quashing of 263 order. ITAT quashed it, and then the revenue preferred an appeal before this honorable court. But meanwhile, after 263 order in the middle, well, a fresh assessment order was passed, and CIT appeal held in favor of the assessee, and ITAT dismissed the revenue appeal, which has attained finality. Therefore, this appeal in our respectful submission becomes infructuous.
And what is the right hand column?
Now, that is the original assessment order before 263 that had come till the High Court, and it was dismissed on monetary limit ground. So original assessment also that has attained finality, and after 263 fresh assessment order has also attained finality.
The department is saying the records are not available to the office of the DCIT relating to the 2011.
Yeah, because everything has attained finality, it would have gone to the
That
record.
I understand, my lord.
So we will record and dispose in case.
My lord's last order, my lord, has recorded these dates.
Yes, this appeal has been filed by the revenue under section 260 capital A of the Income Tax Act 1961, challenging the order dated 15th July 2016 passed by the Income Tax Appellate Tribunal, A Bench, Calcutta within bracket Tribunal in ITA number 547/KOL/2011 for the assessment year 2006-7. The appeal was admitted on 24th January 2022 on the following substantial questions of law. Following substantial question of law. Page 98 of the paper book, only one question. We have heard Mr. So-and-so. When the matter was last heard on 14th July 2025, the learned advocate appearing for the respondent assessee submitted that the appeal filed by the revenue has become infructuous. Therefore, an order was passed on 14th July 2025 directing the department to give written instructions to the learned senior standing counsel. By email dated 28/7/2025, the learned senior standing counsel has been informed that the papers are not available with the department and seek time to furnish the relevant information. Considering the facts and circumstances of the case, we are of the view that no useful purpose would be served by keeping the appeal pending in the light of the following reasons. The original assessment was completed under section 143 within bracket 3 by order dated 31st December 2008, as against which the assessee filed appeal before the CITA, which was allowed by order dated 28th January 2011. The revenue challenged the said order before the tribunal in ITA number 601/KOL/2011, which was dismissed by order dated 8th April 2016. The revenue challenged the said order before this court in ITA number 58 of 2018, which was dismissed by this court by judgment dated 8th April 2016. When the on the same date, when the appeal filed by the assessee against the original assessment was allowed by the CITA, when the original assessment was framed under section 143 within bracket 3 of the Act by order dated 31st December 2008, the Commissioner of Income Tax invoked his power under section 263 of the Act and set aside the assessment order dated 263 of the Act, and by order dated 1st March 2011, set aside the assessment order dated 31st December 2008. The said order passed under section 263 of the Act was challenged by the assessee before the tribunal in ITA number 547/KOL/2011, which was allowed, quashing the order passed under section 263 by order dated 15 July 2016, against which the present appeal has been filed. In the meantime, pursuant to the directions issued by the Commissioner under section 263 of the Act, the assessing officer took up the assessment for fresh consideration, and fresh assessment order was passed on 30th August 2011. Agreed by the same, the assessee preferred appeal before the CITA, which was allowed by order dated 12th December 2013. The revenue challenged the said order before the tribunal in ITA number 421/KOL/2014, which was dismissed by the learned tribunal by order dated 1st March 2017. And no further appeal has been filed against the said order, and the same attained finality. In the light of the above facts, the present appeal filed by the revenue has become infructuous. Accordingly, the appeal stands dismissed, and the substantial question of law admitted for consideration is left open.
The instruction we kept on the record.
Yes, you have said.
My lord, in the starting part, my lord has dictated that in the first assessment, my lord, the High Court proceeding which was dismissed as, my lord, that date has gone as 8th April 2016. That will be, my lord, 22nd January 2025.
24.
Only told this.
The original assessment. Against the original assessment, revenue preferred an appeal before this honorable court against ITAT's order,
Which was dismissed on?
monetary limit ground, on 22nd January 2025.
That date you have not given.
Yes, my lord, this is.
I said 8th April. Instead of that, 22nd January 2025.
My lord, I am grateful. I am grateful.
Monthly list.
From the monthly list of August, item number 1.
Lord, in this matter, Mr. Abhradip Maiti is appearing. My lord has directed for fresh service yet to be completed. I am told that, my lord, we have sent it to the department for service from the end of the department, but till we have to receive the report from the department, my lord. If your lordship kindly grant some time, my lord.
Mr. N.K. Chowdhury appeared for the assessee.
A.K. Chowdhury. No, A.K. Chowdhury. A.K. Chowdhury.
All right. Matter stands adjourned to enable the appellant department to complete service of notice on the respondent.
Grateful, my lord.
3 weeks.
Item number 2.
Item number 2, my lord.
I am for the appellant, my lord.
Yes.
But I am for the appellant.
My lord, last
is-
professor and senior advocate Chakraborty was appearing, Somir Chakraborty. But I am told by his junior that Abhijit Vishwas that now he has left the bit, some other advocate has been engaged by the company.
The advocate on record still is there, or he has also returned the
He
brief?
has returned the brief, my lord. Abhijit Vishwas.
So Avijit Biswas is not there.
Not there, my lord. He has told me that he has already company engaged some other.
And what is the 393 days, Mr. Bhattacharjee?
My lord, there is a delay because, my lord, what happened, my lord, earlier, one additional commissioner, my lord, was an additional charge of the whole day, my lord. And he received the order impugned on 6/12/2023. My lord, thereafter, he again transferred from that, my lord, whole commissioner additional charge has been gone. Then, my lord, it was misplaced. My lord, it is a departmental misplaced, my lord. Once, my lord,
No. When he was transferred, he took the copy of the order also with him, is it?
no, my lord, he was
Ah,
additional, my lord, unfortunately, he was in additional charge. My lord, that is a
Sir, this is all public sector company. What was the allegation?
Malay allegation, it is a simple case. Malay, it should be remand back to the tribunal. Malay. The issue is that, my lord, whether the ISD, whether the, my lord, ISD distributor company is liable to pay the, my lord, tax, or the ultimate user, my lord, who receive the, my lord, ISD, he will pay the tax. Who will pay? This is the issue, man. Very simple issue that was not considered by the, my lord, tribunal. Last paragraph 8, if you lordship kindly sees, that it has to be remanded back to the tribunal to decide this issue. Coordinate bench of the other tribunal, my lord, in similar case, IOCL, my lord, I have the judgment, my lord. There it has been held that no, the ultimate user, he will pay the tax. Well, that is the issue here, my lord. If your lordship, my lord, paragraph 8 kindly sees, my lord. May I place, my lord, paragraph 8, my lord, at page 67 of the stay application, my lord.
আমাদের নামটা দিয়ে দেন। এটাই স্যার আমি আছি। আপনি আছেন তো? আমি নেই। আর কি আছে? 1 নম্বরে তোমরা আছো তো? সেইটা আমি, সেটা আমাদের matter। দিয়ে দে।
Each of the impugned order is missing.
My lord, kindly, my lord, see, my lord, paragraph 8, last 3 lines. At page
No.
67.
It's here. Wait. Please wait.
Hello.
Commissioner's finding is well justified.
Like commissioner also, my lord, I think, my lord, this question, whether, my lord, what happened here, my lord, the ISD between several units of a corporate body is a facilitation by which the availment of credit is made convenient when there are more than one unit. Therefore, my lord, Senvat credit, my lord, irregular availment of Senvat credit, my lord, I have to recover from the persons who actually utilize it. Well, I cannot, well, there is no mechanism, there is no law also, my lord, to recover this thing, my lord, from the ISD. And my lord, the coordinate bench of 2023 Chennai Sistat, and also the similar case of IOCL, my lord, Indian Oil Corporation, my lord, similar case in, my lord, 2014, my junior will hand over the judgment, my lord, you will also find similar issue held that no, it is correctly so called was issued, and the, my lord, availment of wrong, irregular availment of Senate Committee will be realized from the person who actually utilized the my lord, ISD. Because ISD nothing but only distribute the, my lord, to more units.
Just a second.
My lord,
Then
kindly
what-
say judgment
no,
of
what-
2023, my lord.
What do you say about the circular issued by the board?
Well, paragraph number 4, my lord.
Circular is very clear. That has been discussed in page 48, para 5.3. In terms of the board circular number so-and-so dated 23/8/2007, the phrase place of removal needs determination, taking into account the facts of an individual case and the applicable provision. The phrase place of removal has not been defined under the central Senvat credit rules. In terms of rule T of rule 2, if any words or expressions are used in credit rules and are not defined therein, but are defined in Central Excise Act, Finance Act, they shall have the same meaning for the credit rules as assigned to them in those acts. So therefore, they refer to section 4.
Now, my lord, thereafter, my lord, another circular notification was issued on 1st March 2008. The words clearance of finance products from the place of removal is substituted by clearance of finance products up to the place of removal. My lord, if your lordship kindly come to page 6 of my state petition F, kindly see, my lord, I have stated there, my lord.
No, before that, 389 days delay.
My lord, that is, my lord, your lordship kindly, if you say, had it been, my lord, intentional delay, my lord, I will not make any prayer before lordship condonation. My lord, what happened? Well, it's my lord, rather, my lord, totally unintentional, my lord. The person in charge was additional charge of the holder commissioner, my lord. He ultimately transferred. He received it.
Sir, people will come, sir. People will be transferred. People will retire. I'll also retire next month. Do you mean to say that everything will come to a standstill?
My lord,
Institutional function.
My lord, may I
Additional commissioner will move out. Assistant commissioner will move out. Inspector will move out. If suppose it was an assessee's appeal.
My lord is absolutely correct.
Delay tooth and nail.
My lord is absolutely correct. My lord is absolutely correct. I bow down to
then,
my lord. My
sir,
lord,
if it is 100 days or so, then we can say 389 days, 93 days. You took things for granted.
My lord, condone more than 400 days, my lord. It is up to your lordship, my lord. Kindly consider, my lord. Kindly consider my application. May I place my lord condonation delay, my lord? Kindly, then, my lord, first it should be placed, my lord. My lord, kindly allow me to place my application. What I have stated, then your lordship decide whatever. My lord, in any event, it is up to your lordship's hand, my lord. My lord, we are always playing your lordship.
You waited till he filed an application under the RTA Act, asking for information whether you have filed an appeal or not. Because they are a public sector, they acted guarded. Despite that, you did not file. You received the certified copy on 21st of November 2023.
My lord.
And the memo of appeal was presented on 1/7/2025. In the meantime, he asked for information on April 2025. That's when you woke up. Even then, you did not take immediate action. Then you say the records maintained in the T&R section of Haldia Commissionerate were searched thoroughly. No information of receipt of final order of the tribunal. Urgent time-bound matter related to RTA, etc., etc. Then headquarters section informed they are in the process of tracing it. Then aforesaid letter, after carrying out further search of records maintained in so and so, was issued to the CPI. So you started acting only after April 2025. The
Ma'am.
impugned order passed by the tribunal is dated November 2023.
My lord, my lord. My lord.
Because information was sought for under the Act, RTA Act, and you thought at least then you have to do.
My lord, paragraph 9, if your lordship kindly see, my lord. Paragraph 9, my lord.
Yes, para 9.
Yes, my lord.
Impugned order was received by the Commissioner on 6/12/2023. Respect forwarded to screenshot of movement of receipt. Apparent headquarters CRU sent the receipt directly to the then Commissioner in charge Haldia, Sri Kumar Amarendra Narayan, through e-office receipt. Till date, the same remains in the receipt inbox. Commissioner, and no further movement of the document has taken place. So you take a disciplinary action against Sri Kumar Amarendra Narayan. You issue notice, show cause notice, charge memo.
My lord knows better. My lord knows better than me, my lord.
No.
What happened in the department, your lordship knows. My lord, the persons are your
No,
lordship.
if you suspect any foul play,
My
then
lord.
you should be candid enough to state
My
that
lord, my
this
lord.
particular officer is guilty of.
My lord, I bow down. I bow down, my lord. I bow down.
Ah,
I bow down to your lordship, my lord. I agree with your lordship, my lord. What your
then
lordship?
you are naming Subayu Gupta, inspector, who was holding charge as EDM manager office. Whether these people know you are dropping their names in this affidavit.
My lord.
They are no longer in that occupying that post, and you are dropping his name. Then if we issue notice to him, he will come forward with a different story and making allegations against the present assistant commissioner Samit Roy, saying that what all he says is false. Never drop names like this.
My lord. Sorry, my lord.
That is very wrong, sir.
My lord, we are sorry, my lord.
Then you are saying that Anil Kumar, Sanjay Roy took charge as and
names should not be
received by Sri Kumar
mistake.
Aramendra Narayan's desk,
My lord,
held
it's a
additional
mistake.
charge. Very, very wrong.
My lord, it's a
I
mistake.
think this is the first time I'm seeing you're dropping names.
My lord, mistake on our part. My lord.
You should have informed him, saying that, sir, you have received it in your inbox. You did not do that. What did you do after it? Then if he has come forward to the story, I did. Behind his back, you make all these allegations.
My lord, if your lordship kindly see page number 19, my lord, he has replied.
And we know why show cause notices are issued against public sector. You try doing it with the other person, with judgment, tribunal Ahmedabad judgment. You see the name of the assessee, page 49, para 5.4. You dare not do it to him.
Page 49, my lord.
5.4. You see the name of the assessee?
Stat. Honorable Sister Bench, Ahmedabad. Commissioner of Central Excise, Rajkot versus Adani Pharma.
You dared trying doing this sort of games with that assessee?
My lord knows everything.
Yes, sir. We know.
Everything is black and white. Your lordship knows, my lord. We are under the umbrella of everybody, my lord. What? We are very true advocate here. Your lordship, my lord, addressing your lordship. Try to, my lord, ventilate the grievance. You have been entrusted with the job, my lord. Now, my lord, everything is up to your lordship's hand, my lord. Your lordship have to decide everything, my lord. We, my lord, leave it upon you.
This appeal has been.
If your lordship kindly give some lenience to the department to pay something, and my lord kindly hear the matter.
Appeal filed by the department under section 35 capital G of the Central Excise Act 1944 is directed against the final order dated to 21/11/2023 passed by the Customs, Excise and Service Tax Appellate Tribunal, Kolkata, within bracket tribunal, in Excise Appeal number 70099 of 2013. The revenue has suggested the following substantial questions of law for consideration. Page number?
Page
number 19, my lord, of the state.
Page 19.
Paragraph 25.
A, B, C, D. E not required. We have heard Mr. Uday Shankar Bhattacharjee, learned senior standing counsel, assisted by Mr. Topan Bajaj, standing counsel for the appellate department. Though the respondent has been served, none appears for the respondent assessee. Before we examine the merits of the matter, the first hurdle which the department has to cross is on account of the delay in filing the appeal. The appeal has been filed with a delay of 393 days. Full stop. The impugned order was passed by the learned tribunal on 21/11/2023, and the copy was received by the appellant department on 6/12/2023, and the appeal memorandum was presented before this court on 1/7/2025. In this process, a delay of 573 days had occurred after deducting the 180 days, the time given for preferring an appeal in the Act. The delay has been computed at 393 days. We have carefully perused the averment set out in the affidavit filed in support of GA1 of 2025 and elaborately heard the learned senior standing counsel for the appellant revenue. The affidavit proceeds to blame two of the officers, one of whom is in the rank of commissioner, who was in the rank of commissioner, and he was the commissioner in charge of the Haldia Commissionerate at the relevant point of time. Apart from that, another officer has been named. No, apart from that, two other officers have also been named in the affidavit. What is full stop? What is interesting to note is that the department took steps for preferring the appeal only after the respondent assessee filed an application under the Right to Information Act 2005 within bracket RTI Act on 17/4/2025 requesting providing information as to whether the impugned order passed by the tribunal dated 21/11/2023 has been accepted by the department. From paragraph 4 from paragraph 4 up to paragraph 15, the affidavit proceeds to hold certain officers responsible for the delay. In paragraph 17, the department would state, after going through the impugned order dated 21/11/2023, the department put up the matter before the concerned section to ascertain the feasibility of preferring appeal against the impugned order. And the concerned section ascertained that there is sufficient grounds for preferring appeal. And thereafter, the department put up the matter before the competent authority for perusal and necessary approval for preferring the appeal. The said paragraph 17 is absolutely bereft of particulars, and no dates have been given as to when the impugned order was examined by the appropriate authority of the department, as to when they formed an opinion that it is a fit case to prefer an appeal. Paragraph 18 states that after having necessary approval from the competent authority, the department on 18/6/2025 engaged the panel counsel for taking steps to prefer an appeal against the impugned order. Once again, this paragraph is also bereft of any particulars as to on what date an approval was granted by the competent authority to engage a counsel. Therefore, we are of the view that the delay, which is inordinate, has not been explained. Rather, the department appears to shift the blame on certain officers who are no longer holding charge of the concerned department. And it is also not clear as to whether those officers are aware of the fact that their names have been mentioned in the affidavit filed by the department, which would prima facie show that those officers have been blamed for the delay. In any event, the explanation offered by the department for the inordinate delay, apart from being devoid of any particulars, cannot sufficient cause for condoning sufficient cause for exercising any discretion in favor of the appellant department. Accordingly, the application in GA number 1 of 2025 is dismissed. Consequently, the appeal stands rejected. Full stop. The substantial questions of law suggested are left open.
Grateful,
Sorry, sir.
I'm grateful, my lord.
Next.
For admission of tax matters, item number 3.
In this matter, on behalf of the Minister of Law and Justice, Mr. A.S.G. Land, A.S.G. is appearing, my lord.
Now what has happened, sir? It's been hanging for too long. We'll dispose it of. Huh? What else? We have tried our level best to do it. Huh?
I filed an affidavit on last occasion. Copy was given to him. In the meantime, Ministry of Law.
Or you can do one thing, you file a writ petition. That's the best. Then they can't do anything. They have to file an affidavit in opposition. You make a claim along with interest at 18%. And you do it for your S12 colleagues who are now part of the bench.
What I can suggest, my lord, today, my lord, can adjourn the matter.
How long we have to? It doesn't augur well, sir.
Well, the main issue is, my lord, in the meantime, the learned ASG filed a report here, and there is a discrepancy regarding funding is concerned. Well, kindly see that.
This we took it up on ourselves because we were able to appreciate the difficulty you are all going through. So there is a beyond a particular point we can't stretch the matter. In this application has been filed by the department to condone the delay. No? Condone the delay, no? We are not at condone. Condone the delay in filing the appeal. However, the court had kept the application pending, taking into consideration the plight of the learned senior static counsels who are appearing for the department on account of non-settlement of their fee and expenses bills. Time to time, directions were issued and reports were submitted. Pursuant to the last order, the Commissioner of Income Tax Judicial Kolkata had submitted a report dated 31/7/2025 addressed to the Registrar General of this court. Copy is with you. Copy of such report has already also been furnished to the learned senior static counsel appearing for the department, more particularly to Mr. Samrajit Roy Chaudhary, advocate. We sincerely hope and wish that the department takes earnest steps to settle the fee bills, since some of them are no longer the panel, and on account of the present position, they will not be in a position to address the department. Let the appropriate authority of the department bear this in mind and ensure that the fee bills as well as the bills submitted for the expenses incurred by the learned standing counsel are not kept pending and settled on a periodic basis without so that the learned counsels appearing for the department will be in a position to discharge their duties efficiently. Full stop. With the above observation and with the fond hope that the department will take the matter seriously, we deem it appropriate to close the present proceedings and with the aforementioned observation. This will be that. Then in GA1. This appeal has been filed by the department under section 260 capital A of the Income Tax Act 1961. within bracket challenging the order dated 10/3/2021 passed by the Income Tax Appellate Tribunal C Bench Kolkata within bracket tribunal in ITA number 2456/KOL/2019 for the assessment year 2012-13. There is a delay of 657 days in filing the appeal. The impugned order was passed by the learned tribunal on 10/3/2021, and the copy of the order was received by the department on 6/7/2021, and the appeal memorandum was presented before this court on 22/8/2023. In that process, a delay of 777 days had occurred, and after deducting 120 days, the time provided under the Act, the delay has been computed at 657 days. Full stop. We have gone through the affidavit filed in support of the application, and we find, except for stating that the files were moving from one table to another, from one officer to another, no satisfactory explanation has been given for the for condoning the inordinate delay of 657 days. Thus, we are not persuaded to exercise any discretion in favor of the appellant department. Accordingly, the application in GA 1 of 2023 is dismissed, and consequently, the appeal stands rejected. The substantial questions of law suggested by the revenue are left open. Sorry, sir.
Much obliged, my lord.
Next.
Item number 4.
Your Lordship, on last occasion, Your Lordship had directed the appellants, which would be me, to file an affidavit explaining why we were not present or why on 18 occasions we were not there before the tribunal, Your Lordship.
Because you are blaming the advocate.
Lordship, it's not exactly a blame. We filed an affidavit, Your Lordship, explaining our stance.
Paragraph 4 is unbelievable. Page 4, paragraph 4. He is regularly appearing before the tribunal, and wherever he appears before the tribunal, before this court, Mr. S.M. Surana appears. So this is unbelievable.
Lordship, I believe there may have been something going on between the advocate and the assessee, due to which the assessee decided to change his advocate.
Where is the impugned order that passed by the tribunal?
Lordship.
Partly you succeeded before the tribunal. No.
But, Lordship, no, your Lordship.
Where is the impugned order?
Lordship, I'll just take your Lordship. That would be at page 186, your Lordship, of volume 2.
Well, it is also with the memo of appeal.
Lordship.
But then the tribunal took note of your written submissions,
Lordship.
and then they have examined the records and found that the genuineness of the transaction is not there. It's a penny stock, artificial increase within less than 2 years. The value appreciated.
Lordship, those are the allegations.
You purchased the shares for 60,000
Lordship.
and sold it for 10,76,990.
Lordship. After holding it for a period over a year.
Only without two issues subject to lordship
Lordship,
correction. There are two issues in the Milord appeal. One is the assessing officer did not give full information to the assessor. Second is the assessing officer did not apply his mind. He is only relying the report of the investigation. But in the two scope, the CIT appeals and the ITAT pass detailed order. And the tribunal also rely the judgment of your lordship and Honorable Justice Bhattacharya and Sati Bajaj is relied by thereafter whole of India.
But Mr. Bhatt, one thing, in this affidavit, you have mentioned the names of Mr. Shantanu Chakravarti, Ritish Goyal, and Mr. Saurav Bagaria. Are they aware of that in this today's affidavit?
My lord. Their names are recorded in the court proceeding. So, my lord,
are they aware that your assessee has filed an affidavit mentioning their names?
No, my lord. They're not, my lord.
And one day will come, somebody will mention your name.
I understand
in an
that, my lord.
affidavit somewhere.
Should have.
Your
No, we should have, my lord. We should have.
How many days? There's a delay, is it? No delay.
No delay, my lord. My lord, the only issue, my lord, why we had filed the affidavit, my lord, it very correctly, my lord, fell from your lordships that today, if they have taken adjournments of 14 times, my lord, that was the recording in the order, and that they have changed lawyers more than 7 times. So then, my lord, it is on us also, my lord, they may do the same. But then we ascertained, and then we came to know, my lord, from the court records, these adjournments were basically, they had appeared, they had made their, they had submitted written submissions. And the lawyers, there was only one change. First, there was a set of lawyers. They, changed. Then, came in the second set of lawyers who continued, So it is, through that, Wakalatnama, the council was engaged and they appeared. And that is why, it sailed through, they had appeared.
And my lord, one day there was another junior who was engaged
But
by
then,
the
you are
advocate on
you are
record.
telling your colleague
My lord,
that the averment in para 4, page 4
My
is
lord.
wrong. He is regularly he appears before the tribunal, and before the High Court, wherever he has appeared, Mr. S.M. Surana has used to appear. In the order sheet, we find the names of the person mentioned in para 4
My lord.
as well as Mr. S.M. Surana.
My lord, what we found is perhaps this was the first change. From Mr. Surana, my lord, it went to Mr. Goel, and Mr. Goel continued with the matter.
No, Mr. Goel engaged, asked Mr. Shantanu Chakraborty to appear.
That is his junior, my lord. He is his junior.
Correct.
My lord.
And you say they are all part of the legal team of Saurav Bagaria.
But they were appearing together in the sense, my lord, that he was instructing, my lord, as a counsel, Mr. Bagaria. So, my lord, they had appeared. It is our fault, my lord. We should have informed Mr. Bagaria and Mr. Goel. That is what we should have done.
You better tell them.
We should have, my lord. That's
Because
completely missed it, my lord. It's
on
something I
12th
should
of
have.
October 2023,
My lord.
Mr. Bagaria appeared along with Ritesh Goel.
My lord.
You just orally inform him.
We should, my lord. We will.
We will not record anything.
Absolutely. This is my fault. I take it on
Just
myself.
orally
I should
inform.
have, my lord. I will.
Because
I
he
will.
shouldn't take it
No,
otherwise.
indeed, my lord. It's something I should, as a professional, my lord. I should be.
This goes on record.
Indeed, my lord. Indeed. I apologize, my lord. This is something I should have done before coming before the honorable.
You'll just adjourn
My
it.
lord. My lord, may I also indicate one thing, my lord, if my learned friend can take instruction on that. My lord, the main point which I am going to argue in this matter is, my lord, the amalgamation. That's my distinction from all the other judgments, including, my lord, Swati Bajaj, because that's not hitting us in any manner. Today, my lord, if it's through an order of the court that, my lord, the value of the shares change, it's through amalgamation. I have nothing to do with this. And that's my main point. So today, my lord, the distinction is that if here, my lord, the facts are only threefold. The assessment year is 2012-13. We had purchased 300 equity shares, my lord, of Heritage Wind Trade. This is the company. 300 equity shares of this, my lord, from Kamdhenu Como Cells. This was, my lord, in the year 2009, December, where the price was 200 rupees per share. That was the original price, my lord. So we invested 60,000 rupees. This was transferred by the petitioner to Heritage. This is the company, my lord. And that was on 30th of December 2009. This is when the transfer is made. But the books of account, this is disclosed. Thereafter, my lord, after 2 years, in between Heritage and Multiplex Resources, there is an amalgamation. Now, the difficulty we faced in the beginning was, my lord, we didn't have this copy of the amalgamation order.
Then you file a compilation.
So then we filed in the compilation also, it's not there, my lord, because we didn't have the order.
So now you file.
My lord, it's there in the order of the Income Tax Appellate Authority, my lord.
No. Your written submissions and the order approving the amalgamation by
That is something, my lord, we are not able to, my lord, find. But then
no, it will be uploaded. No?
It's not. It is in 2009, my lord, that phase, there was no, my lord, uploading, so we couldn't actually, my lord, gather this. But it's not required because what we found is from the order impugned, this entire process is recorded. And it's also recorded that there is an amalgamation. And through this amalgamation, my lord, these two companies, Heritage and Multiplex Resources, my lord, they come together. Then in the second week of December 2011, that's 2 years later, my lord, through a registered share broker, online trading of CACL, the rate was at 180 per share. The amount was 10,76,990. That's the capital gain, that's there. That's what they're indicating. With all these documents, we filed a return in 2012. So everything on record. Now, after everything being on record, this has come back after a reassessment under 143.1, and there was a 148 proceeding which culminated in a reassessment proceeding under 143.3 and 147 on 18th December 2019. This is the initiation of the present proceeding. So today, if there was no amalgamation order,
orally inform them.
We will.
In terms of the directions issue, an affidavit has been filed by.
Now, what my learned friend says, that is not appearing in the CIT appeals order. Now, I
I
take
show from the order.
Now, it is something new from the bar.
No, definitely
because he is the new counsel who has been engaged. Has been filed by Ajay Kumar Singhania, who's stated to be the Karta of Ajay Kumar Singhania HUF. The affidavit is taken on record. A copy of the same has been served on the learned standing counsel for the respondent. Adjourned.
Page 190. But next day when I come back, I'll start from this page 199 because my learned friend has said it's not there. It's there at page 199. I'll come back with that. Very deeply obliged.
Come to come.
Item number 5.
But I'm appealing this case. May I file my service note? The short point, Ilvam, before your lordship, this reopening was barred by limitation on the ground, my lord. Although, my lord, notices were signed on 31st, but issued first. My lord, first at 7:50. Your lordships, my lord, lordship will kindly seize the tribunal's order, my lord. And my lord, this your lordship has already, my lord, in one of the matters, my lord, lordship has the occasion to, my lord, deliver a judgment, my lord. Lordship will kindly have a look at that, my lord. Relying on a Information Technology Act, my lord, and my lord, section 282 and 282 capital A of the, my lord, Income Tax Act. May I also hand over to your lordship the, my lord, the sections, my lord. And also, my lord, your lordships has, my lord, gone through the judgment of a my lord. That is, my lord, Suman Devi Agarwal was also considered by your lordship, my lord. But first, my lord, if your lordship will, yes. And also, my lord, the judgment of, my lord, Bagadia Properties and also, my lord, Manoj Jain was also considered by your lordship. But may I also? Lord, I have handed over to your lordship the relevant provisions, my lord, section.
But this is against you.
Yes, my lord, this is the lordship has, my lord, decided this matter in that format. But no appeal has.
See, it is within your control.
Yes.
And the tribunal relied on some Sandeep Kumar.
Yes, yes.
Was the my lord,
But also, my lord,
tribunal was the notice, my lord, section 148, my lord.
But also, my lord, your lordship, my lord, in that case, my lord, Suman Devi Agarwal was also considered. We have argued the judgment of Suman Devi Agarwal, my lord, where your lordship has said that this is in favor of the SSC of relying, quoting on that provision that relying on.
You come to page 118.
118 of
this stay petition.
Yes, yes, yes. 118, yes. Yes, my lord.
Last paragraph.
Yes.
That is that extracted portion, para 6.
Yes.
Notice in this is so so. So how the same was emailed to jurisdictional high court in the case of Madura Wind Trade Private Limited. So on so on. So our is actually uploaded so on. So thereby treating the quashed the. Where is the judgment?
Madura is not with me, my lord. Because what
we will follow this decision. Please come.
Because your lordship has not also not considered Information Technology Act section 13, 280, 22. The lordship has considered everything.
This appeal by the revenue filed under section 260 capital A of the Income Tax Act 1961 within bracket the Act
Service to be kept on
is directed against the order dated May in ITA number 214/KOL/2024 for the assessment year 2014-15. The revenue has raised the following substantial questions of law for consideration. page number 3, question number A. B. Two questions enough. You have heard so on. So on. The learned tribunal by the impugned order set aside the reassessment proceedings on the ground of limitation. On the ground that the notice issued under section 148 dated 11/3/2021 is barred by limitation. In support of its conclusion, it relied upon a judgment of a coordinate bench of the tribunal in Sandeep Kumar Shaha versus ITO Ward -50 within bracket 1 Kolkata in ITA number 7/KOL/2023 dated 30/11/2023. In the said decision, the learned tribunal has relied upon a decision of this court in the case of Marudar, MARUDHAR, Wintrade, VINTRADE, Private Limited versus Union of India and others. In WPA 4382 of 2022 dated 12/4/2022. Identical question was considered by this court in the case of the Assistant Commissioner of Income Tax Circle -13 within bracket 1 Kolkata versus Ramakrishna Bimal Kumar Private Limited, APOT 231 of 2023. And filed by the revenue of dismissed. The relevant portion of the said judgment is quoted here and below. So page 2. Thus, following the above decision, we approve the decision taken by the learned tribunal and dismiss this appeal. Consequently, the substantial questions of law against the appellant revenue.
Item number 6.
Lord, I'm appearing this case. Lord, on the last occasion, your lordship was pleased to direct me to take instruction regarding the judgment which they have cited, my lord, in the case of Prakash Krishnadhar, whether there was any, my lord, against any appeal was preferred or not, my lord. But to the best of my lord, I have checked, my lord, they are saying some time is required, but they are saying that till now we don't have any information
But we have
regarding any
checked.
appeal have been preferred or not.
We have checked. There's no appeal file. This is
You get written instruction.
Yes, I'll take this instruction.
Don't.
Yes. Lordship will kindly adjourn for 1 week.
we have checked from the website whether there's any in the Supreme Court whether there's any appeal preferred which is pending.
Just to safeguard his
Yes.
We passed an order, is it? Please show the order sheet.
Yes, your lordship has passed it. I have a copy of it.
On 18/7/2025.
18 July. madam.
No, I go there. Sir, reference may be made to the order dated 18th July 2025, which reads as follows from second paragraph, second and third. The learned advocate appearing for the appellant department seeks some more time to get appropriate written instruction from the department. The learned advocate appearing for the respondent assessee submitted that they have caused due verification and have found that no appeal has been preferred by the department. against the judgment in the aforementioned matter. The appeal stands adjourned to enable the learned advocate for the appellant department to get written instruction from the department. Next.
I'm deeply speak.
Item number 7.
We have received instructions from the client to appear in this matter only last night, Your Lordships. Then we received a scanned copy of the brief today in the morning. If Your Lordships would be kindly pleased to fix this matter on 7th August, this Thursday, Your Lordship.
What is the tax effect involved in this appeal?
But perhaps 21 lakhs or something. Has been raised for 21 lakhs 97,000. Paragraph number 6 of the stay petition. তো পড়ি রাই ট্যাপ থেকে
No, their point is there are two notices issued under 148. And the first notice was pending, the second notice was issued. And according to them, their objections were not disposed of by passing a speaking order.
My Lord, may kindly permit us to come back day after tomorrow.
You don't have the papers.
We just received it today in the morning.
We also received it just
No, initially the delay was on the next. No, on the CIT appeals order, there is even a clear finding that there were not two 148 notice, only one 148 notice.
All right, let her get instructions.
I'm so
We have heard so and so, so and so. At the request of the learned counsel for the respondent assessee, adjourned. Keep it after 2 weeks.
Item number 8.
Here first. But what I'm appearing for the department. The access is appeals.
Nobody is there.
My lord, there are few cases where the department order has been passed in favor of the department, SSC's appeal dismissed in my lord penny stocks matters.
Where is the assessee?
Lord, last occasion, my lord, learned advocate appeared, but he also taken time last occasion.
Oh, he appeared, Anirban Banerjee.
Last occasion, my lord, appeared.
All right, none appears for the appellant. You have heard Mr. So-and-so. Please, next week.
9 is also my lord, same advocate.
9 also same order.
Item number 10.
Who will appear for the department in item 10? IT 24 of 2025. Last time you accepted notice, Mr. Bagh appeared.
Item 11.
You don't have the brief.
I don't know.
No, last time your name is recorded.
My lord, I have not.
Item 11.
Oh, my lord, I have informed them, but they have not given. Brief was not.
Yes, yes, you're appearing.
10.
11. I mean item 11.
So, 10
is
copy has, I think, not been served.
Oh, sorry. This is item 10 is Chicago commodities. This is Rajesh Agarwal.
Item number 10. But
IT 24 or 25.
item number 10, my lord.
I think a wrong case file has come. But the cost title is different. It says Rakesh Agarwal. But that is not listed today. 24 of 2023. All right. What should we say? Nothing. No? Not today.
Not today.
Item number 11.
11.
Item 11, minute, I'm appearing for the respondent.
But I'm appealing for the appealing matter. On the last occasion, delay has been condoned. The addition is it was a reopening, and addition was made on the basis of the accommodation entry that has been carried out by the assessee for the relevant assessment here. Your lordship would find page 11, the assessment order wherein the process of reopening has been indicated, wherein 148 notices has been served. কি করে এটা কোথেকে পেলো কোথেকে পেলো The disturbing factor, my lord, the recording of the assessment officer that is appearing at page 13, my lord, wherein, my lord, regarding, my lord, the genuinity of the transactions, my lord, the assessing officer has gone on to hold that there was no, my lord, document to, my lord, prove to the transactions. But on the other hand, my lord, the tribunal, if your lordship turn to page 32 of the step petition, paragraph 9, where, my lord, the tribunal had, my lord, dealt with that issue. Tribunal said that those has been filed before the assessing officer, as well as before the learned CIT appeal as well.
But there were two appeals before the tribunal. One was remanded back to the AO, that is ITA 760.
At 759 and 760, one was remanded back to
760 was remanded, 759 was allowed.
Yes.
But 759 also, what was the appeal number?
759, that's page 31 before paragraph 6, my lord.
Correct. That is for 2010-11.
10-11.
Where is the order passed by the CIT appeals dated 8/6/2023?
It's not annexed. 20 page 21 is, my lord, 26/5/23.
No, sir. 26.
It's not annexed, my lord.
Is for the assessment year 10-11.
My lord.
Okay.
But, my lord, we have assessed, my lord, the assessment year 10-11 itself.
Lord, if your lordship kindly takes up page 29, the first paragraph, third line, my lord. 26/5/23 is for, my lord, 2010 and 11. And, my lord, 8/6/23 is, my lord, for 13-14.
Yes.
13-14 they have not challenged.
I have not challenged.
They have challenged, my lord, 10 and 11, which is 26/5/23, for which, my lord, the CIT appeals order is at page 21. Yes, my lord, we'll be contending, my lord, there's no substantial question of law involved at all, because, my lord, the facts are there in paragraph 7 and the findings at paragraph 9, which is, my lord, pages 31 and, my lord, 32 onwards. And I'll indicate, my lord, all the factual findings here, my lord, do not give rise to any substantial questions of law, because it has been, my lord, held by the tribunal after, my lord, discussing the facts in paragraph 7 in details, that it doesn't fall within the ambit of section 68. But the reasoning is, my lord, from paragraph 9.
The assessing officer.
That is, my lord, something, my lord,
But
which are
the
indicated.
company in which the assessee invested was also functioning in the same address. That's what the CIT appeal says. But then you went before the tribunal contending there was a change of address intimated.
My lord. And that's recorded, my lord, in paragraph 7.
No.
Shifted to new address, your lordship will find
That
the
was
last.
that was what was your plea before in your grounds of appeal? You please show CIT appeals grounds.
My lord, the grounds of appeal, my lord, is not annexed here.
Yes.
Oh, yes.
No. That is paragraph 4, page 22.
That is as vague as possible. Because the CIT appeal says page 24, para 6.3.
My lord. Also 6.2, my lord, the first paragraph, where, my lord, AO in the assessment order has stated to verify genuineness of the said transaction. Summons was issued under 131 at the address of the company, also available in the MCA website, Oloka House, Kolkata 1. One inspector was deputed to serve summons. Personally on the director of the company, but the inspector intimated the company was not found at the state address. Thereafter, the next paragraph, appellant in its reply submitted that they are enclosing documents, genuineness of the transaction. That's 6.3, my lord. Where, my lord, the details of, my lord, company's website are given. Your lordship will find A to E.
At page 24, it says when the assessee communicated to this office, the inspector in charge was sent to the aforesaid changed address,
My lord.
Bentic Street, Reported no signboard, banner displaying the company at the address. Company remains unfound. Therefore, identity is not established. Then if you see the reply, the extraction of the reply, ledger copy of Vyapar Limited showing received rupees, how much is this? 20 crores, is it?
20 lakhs, my lord.
20 lakhs.
20 lakhs on
20 lakhs.
17/11/2009.
Okay, 20 lakhs also and 10 lakhs also. Then the appellant submitted details of
20 lakhs.
30th Vyapar as appearing ministry. If you come over the page 25,
My lord.
registered address is Aloka House, first floor, 6B, Bentic Street. Same address.
That is, my lord, the unchanged address. That is what is considered, my lord, by the ITAT. Your lordship will kindly.
This ground which you are raised before the tribunal.
My lord. But that's discussed in the last 5 lines of
which is
paragraph 7.
accepted. The tribunal has not noted that in the changed address the inspector went.
Yes. My lord, it is. May only indicate that.
Please show.
Your paragraph 7, your lordship will kindly take up the last 5 lines. It is pertinent to note. This is, my lord, page 31, paragraph 7. The last 5 lines, it is pertinent to note that during the year, the registered office of the SSC company was under renovation, and therefore the office was shifted to a new address, and the AO was duly informed to the new address, which was 85 Benting Street, Calcutta, and the phone number is given, my lord. However, the AO deputed the inspector to visit the SSC's office on the old address, where the inspector did not find any person of the company, and accordingly, the inspector did not visit the new address.
That is false. Contrary to finding at page 24.
My lord, kindly also see, my lord, the next page.
Also, the appeal is admitted on the following substantial questions of law: A, B, C, D, E, and F. The usual order for that.
We have also, my lord, taken a point of cross-examination, which, my lord, will rely on your lordship's decision.
False statement. Next.
Get full, my lord.
Item number 12.
Deeply obliged.
But after the respondent. Respondent.
Lordship 12 and 13, I'm seeking for an accommodation. Mr. Chakravarti, if Lordship can keep it not today.
Item number 14.
But after respondent. Is the one. Respondent. 14. Yes. 14. But as 14 and 15, I'm appearing in 15. Right?
14, 15.
It's same here.
But 14, 15 are connected matters. And if we take 15, it would be better, my lord. 14 can be easily disposed of if we take 15, because it is all in capacity. पहले 15 का 14 you can see it.
Okay.
This appeal was heard earlier.
No, brother.
Lord, this is SSC is a cooperative society, and the basic issue is no more res integra. The amount they are investing in fixed deposits with banks, the interest they are receiving, whether that will qualify for deduction under 80P or not, that is the main issue. Lord, substantial questions of law are at page number 14, my lord. Basically, three issues are there. Interest on FD with bank, whether it will qualify for ITP deduction or not. Next is interest on personal loans. The SSC is having individuals as well as entities also as their members. So giving of loan to the members, that interest qualifies or not. House building loan to staff, and there are certain sundry income, whether that will qualify or not. My lord, AO has dealt with the issue at page number 51, my lord. Last parameter.
Yes.
The SSC has credited an amount of so much towards interest received and receivable, out of which an amount of 3.84 crore has been earned from interest on deposits with bank, and so much was earned by way of dividend. Again, out of bank deposits, an amount of 1.01 crore was earned by way of interest received from deposits with Cooperative Bank, and rupees 2.83 crore was earned by way of interest received from other than cooperative banks. This is the bone of contention, 2.83 crore. In other words, as per statute, rupees 1.01 crore and also rupees 11.35 crore are eligible incomes as per section 80P2D of the Act. However, interest either realized or accrued from deposits with other banks for an amount of 2.83 crore remains ineligible for deduction under 80P2D of the Act. In this context, reliance is placed on the decision of Apex Court in the case of Todgar's Cooperative, in which it was held that interest earned by appellant cooperative society on surplus funds invested in short-term deposits with bank and in government securities are not eligible for deduction under 80P.
But in so far as the other amount, they have allowed it.
Other amount means some of the interest SSC was receiving from cooperative bank. So there is the specific provision is there.
Very good.
So there he has allowed.
But what about this 11 lakhs 35,000? That is eligible.
That is also eligible. No dispute on
But
that.
however, the accrued from deposits with other banks, other than cooperative, amounting to 283,02934 is
My
not
lord,
eligible.
this is only the issue here. Now, my reply to his so cause is reproduced at page number 52, my lord. The Apex, the cooperative society which is carrying on business of providing credit facilities to its members earns profits and gains of business by providing long-term credit facilities to its members. Being the Apex Cooperative Society of Land Mortgage Banks in the state, such fund is received from NABARD in FY 13-14 corresponding to AY 13-14. I'm sorry, this is AY 13-14. Such fund was received in two installments of 100 crore and 56.34 crore. The said funds were in turn lent to our members in hundreds of installments. This is because we borrow wholesale and lend on retails basis. It is thus inherent in our business that there is always some floating fund. This floating fund has a cost, interest payable to NABARD, and is invested in short-term deposits which yield us income and partly compensates the cost, interest payable to NABARD. It would thus be seen that this activity is integral to our business of lending, and interest earning on deposits is attributable to our lending business only. Then, my lord, the finding has been given in the last para by the AO. The contention of the SSC as stated above is not correct in the light of decision of the Honorable Apex Court. The Parliament has included specifically business profits into the definition of the word income. Therefore, precise meaning of the word profits and gains of business mentioned in 80P2 of the Act are to be given. In the instant case, the SSC society regularly invests fund not immediately required for business purposes Interest on such investments therefore cannot fall within the meaning of expression profits and gains of business. Such interest income cannot be said to be attributable to the activities of the society, namely carrying on business of providing credit facilities to its members. When the SSE provides credit facilities to its members, it earns interest income. As stated above, interest held as ineligible for deduction under section 80P2A is not in respect of interest received from members. Moreover, as per statute, deduction under 80P is allowable on interest and dividends derived by cooperative societies from investment with other cooperative societies. Basically, he wants to say that if I am investing in other banks, my surplus fund, then I do not qualify for 80P deduction. And my lord, then ITAT, that order is at 125.
No, before that, CIT appeals, what did he do?
CIT appeal, my lord, the order starts at page 66. And at page 86, he is giving the decision. And he is basically following the Bangalore bench and has reproduced the order of the Bangalore bench, which in turn has followed Todgar. At page 93, my lord.
Page 93.
93. It can thus be seen that the ratio laid down by Honorable Karnataka High Court in Todgar is that in the light of principles enunciated by the Supreme Court in Todgar Cooperative, in case of a society engaged in providing credit facilities to its members, income from investments made in banks does not fall within any of the categories mentioned in Section 80P2A of the Act. However, Section 80P2D of the Act specifically exempts interest earned from funds invested in cooperative societies. Therefore, to the extent of the interest earned from investment made by it with any cooperative society, a cooperative society is entitled to deduction of the whole of such income under Section 80P2D of the Act. However, interest earned from investments made by any bank not being a cooperative society is not deductible under 80P2D of the Act. This is the excerpts from the Bangalore bench. And finally, his finding at page 94. 7.1.2, in 4 lines, he is dismissing my appeal. The provision is 80P2AI. In the case of cooperative society engaged in carrying on the business of banking or providing credit facilities to its members, then, my lord, after subclause 7, the whole of the amount of profits and gains of business attributable to any one or more of such activities. So here the word used is attributable, not word derived. Derived has a very narrow meaning and attributable has a wide meaning. So this has been in the context of 80P interpreted by various high courts after Todgar.
Where is the tribunal's finding?
My lord, at page 125, tribunal order starts, and at page 127. Is basically reiteration of what AO says. And then at page 132, my lord, para 9, they are referring to the earlier year's order.
That is the other appeal.
Other appeal.
35, IT 8035.
34, but these excerpts are not from ITA number 1434. There were 2 rounds of proceeding in earlier year. So this is the ITAT order of the first round.
Okay.
So there wrongly they have written the number. This is actually 1068 of 2009.
And this 1068 was set aside.
Was set aside. But for limited purpose.
For,
Actually, I have no case in the first year because I had accepted the basic proposition that because at that time much water had not flown down the river Ganges, the general impression was that Toothgar has come and the doors are closed. So we did not carry the matter further in appeal, and for a limited purpose, that interest attributable to that interest, because we are also paying interest to the members. So that expenditure should be allowed. For that limited purpose, it was restored back. That finding is at page 134, para 11, in italics. That finding of the ITAT in the first round.
After rejecting the ATP claim, it was sent back to the AO
for the
to assess the claim under the income from other sources.
Other sources allowing me in expenditure, if any. So this order is being followed here. The finding is at 134 below the italics portion. Since the issue relating to ATP on the interest from banks and cooperative banks has been decided against the SSE in the appeal for 2006-7, hence following the order of 6-7 in the SSE's own case, the order of the CITA is upheld. As far as this issue number 1 is concerned. There are decisions in this regard. First decision is from my lords. This is though in connection with 263, but the finding, my lord, at page 2, para 3, my lord, the last 10 lines of this para 3. And this has to be read in juxtaposition with the question of law. 2 may not be referred to because this is in regard to cooperative bank. So in a strict sense, it may not apply to me. But 3, my lord, at serial number 3, Karnataka High Court, my lord, they have dealt with the expression attributable to appearing in ITP at para 7, my lord, page 8. And at para 11, how Todgar will not apply. The facts were entirely different in Todgar.
Now, this amount which was invested in the bank is not the amount due to the members.
Not due, because I am a.
It is surplus which you have generated. You are investing and earning interest.
That also will apply, but in my case, I have all the more stronger footing because of the fact that we had submitted before the above, which he has taken cognizance of, but given an adverse finding. The fact that I am taking money from the NABARD, which is a government agency for development of rural economy. The agriculturists, we are giving money through our agents who are also banks. So that money that we are receiving there, we are receiving twice a year and then distributing to the members. So that money remains with us, so that we are putting in the bank FD. But even if it is my surplus money, then also I will qualify for my surplus money which I invest in bank.
Because that was provided to you for extending credit facility to your members.
So that has direct inextricably linked with my business of lending money to the members.
We will continue. We have heard so and so for the appellant revenue and Mr. Pruthi. For continuation arguments, list tomorrow.
Tomorrow.
Okay.
We are facing some trouble for filing appeal, e-filing appeals. Last occasion I mentioned to your lordship. Now, it is true. The department till now, department scanning the paper and uploading the appeal. And now it is true. And we cannot pray all occasion department can upload scan the, but all of a sudden if we stop we are facing difficulties.
No, the scanning has not stopped, but it is going in a very slow pace.
No, our instruction is that
side is concerned, just so far as original side is concerned, is stopped, my lord. Appellate side is going on, but original side they have totally stopped the scanning part. Subject to correction.
Why? Suddenly, why you stopped?
Grateful.
The matter, my lord, learned friend has to take the instruction. What will be the consequence? My almost 19 matters are pending before the West Bengal Taxation Tribunal.
Instruction.
And because one of the
Instruction
somebody appeared on the last occasion. I don't know.
See, there's a peculiar problem here.
Yes, ma'am.
Because the
I have seen that. Normal course, what is happening is when they are filing writ petitions because of the, or else we'll lose out on a forum. Let them file a fresh writ petition. Let them.
We'll give you liberty.
Yes, my lord can give the liberty, man. The only thing is that in the other matters, my learned friend is saying, in that matter, one only difficulty is my matter is pending before the tribunal. In the any new matter, we can file writ petition. Whether the pending matter can be filed before the file writ petition.
No, because the.
But I have a suggestion, subject to whatever your lordship would. My lord, several writ petitions have been filed by the port trust, which are pending. My lord, I understand that the technical member cannot take up these matters. He was defending the state as the departmental representative. So, my lord, the only option which, according to me, is available to me is that I withdraw those applications before the tribunal. And your lordship may grant me leave so that I can file petitions before this honorable court.
We can pass such a direction in this itself.
Well, that, yes, certainly.
This writ petition has been filed by the Board of Major Port Authority for Shyama Prasad Mukherjee Port, Kolkata, challenging the order passed by the West Bengal Taxation Tribunal in RN 257 of 2017, dated 6/7/2023. The said application was filed before the tribunal.
ওখানে গিয়ে এটা দেখাবো আমি বলে দিচ্ছি এটা how many petitions
What was the prayer before the tribunal?
Sorry, my lord. Prayer before the tribunal. Prayer before the tribunal. Prayer is at page, my lord, 21. It starts from page 20. And I was directing the essence. Treat the appellant as a dealer under the provisions of sale tax.
Oh, that is the prayer before
Yes,
the
that
tribunal.
is the prayer.
In the said petition, the
tribunal ke annex করা নেই?
no, that's the prayer in the present writ petition.
No, that's a prayer in the present. That is what I was submitting. Kindly give me one thing, my lord.
It is not here in this.
No, it is.
Stay petition, it is not included.
Tribunal is not annexed. Not annexed. Not annexed. Not annexed.
Can you remember what was the prayer?
My lord, I tell your lordship, whatever is the prayer made in the writ petition before your lordship, that's identical prayers have been made before the tribunal.
Okay. Filed an.
But whether my lord, port trust can be treated as a dealer under the West Bengal VAT Act. That's Sales Tax Act. Sales Tax Act.
To treat the petitioner as a dealer under the provisions of the Sales Tax Act 1994.
Right.
In fact, identical prayer has been sought for in this writ petition as well. We are informed that several other writ petitions have been filed by the petitioner port trust before the tribunal, and those cases are also pending.
Page 30, my lord. Page 30.
Pending, as could be seen from Annexure P3.
Yes.
Annexed to the stay petition filed in this writ petition. The learned tribunal had released the matter on the ground that the present learned technical member of the tribunal had appeared for the respondents as state representative. Owing to this situation, the petitioner appears to be remediless. The same objection will arise in the other petitions which are also pending before the tribunal, either as applications numbered as RN or applications which have been filed as review applications against the final.
These are all, these are revisional applications under section 8 of the Tribunal Act.
Revision applications filed under section 8 of the Tribunals Act.
Yes.
Therefore, this court is of the view that, considering the extraordinary situation which has arisen, it calls for appropriate directions. Accordingly, we dispose of this writ petition, giving liberty to the petitioner for trust to file a writ petition seeking for an identical relief as sought for before the tribunal, and also withdraw the
Yes.
application which is now pending before the tribunal.
Grateful.
The petitioner for trust is also granted liberty to file to withdraw the revision applications as well as applications against interim orders which are now pending before the learned tribunal, and file writ petitions before the learned single bench of this court. For better appreciation, for better clarity, annexure P3 shall be annexed as part of this order. Full stop. As and when the writ petitions are filed, the learned single bench may consider the same
Petition with interim prayer.
and pass appropriate orders on merits and in accordance with law. With the above observation, the writ petition stands disposed.
Grateful.
Okay. Next.
I submit. But the issue in this petition is, my lord, that I am a flour mill. I do the crushing of wheat into atta, into the flour on behalf of the state of West Bengal. As per notification number 1/2017, entry 3A, I am exempt provided, my lord, it is a the activity is relating to the panchayat or municipality. But there is no dispute about that I am not entitled to this notification. The government of West Bengal has issued notification that I am entitled to this benefit of exemption. But thereafter, in sometime around 2020, the DGGI initiated an investigation. They called all the flour mill owners to Delhi and forced all of them under the threat of arrest to make payment of tax, substantial amount tax. In this case, the total disputed amount was around 8 crore. Since the inception of the GST law, they forced this particular mill owner to deposit 5.5 crore rupees. The finance minister of the state of West Bengal wrote a letter to the finance minister of the India that this is going on. You please stop this. According to the state of West Bengal, this activity is exempt. Thereafter, my lord, after 4 years after recovery of the tax, in 2024, they issue a so-called notice under section 74. They keep slipping all over these years. If they at all wanted to issue a notice to me, they could have issued notice to me under section 73, but they wait for 4 years. Then in 2022, they say that my activity is a fraudulent activity and I have deliberately evaded the tax and all that. My lord, the only ground is, my lord, that according to them, my lord, I'll just take you through the relevant paragraph of the order and the dispute involved. The dispute which has been framed in the order itself, my lord. Their allegation is, my lord, I am receiving consideration which is in form of cash as well as non-cash. In the crushing of the wheat into the flour, I am supposed to add some nutrients. And I have to pack the item in a bag and give it to the government. So the West Bengal government is giving me a consideration of ₹10 for the nutrients which I am adding and 50 rupees for the packing material which I am giving. Now they have done their own investigation through the various flour mill and all this data they have collected, and they say that this value should be in the range of 81 to 101 instead of the value which the West Bengal government is giving to me. They said this is not the correct value. This 60 rupees cannot be deemed to be the proper consideration. Nobody in their sane mind will sell the goods below the cost and all that. And they consider it to be 81 rupees. Now the problem is that the notification says that if the value of the goods exceed 25%, then I get out of the purview of this benefit of the notification.
25%
of the total consideration. Total consideration is undisputed. That is 260 rupees. My value which is being given to me by the state of West Bengal is 10 rupees for nutrients, 50 rupees for packing material, 60 rupees. So if it is calculated in percentage terms, it is coming to 23%. So well within that limit. But they say no, this value, this transaction value cannot be adopted for this because nobody will sell it below the cost price. So we have done our own investigation throughout the state of West Bengal. The value should be 81 rupees. This transaction value can only be discarded if, my lord, the price is not the sole consideration, and, my lord, we are related party. The state of West Bengal is not my related party. We are a private mill owner. We have been given a contract, and several other mill owners like me have been given a contract. So, my lord, my submission is that I am very well within the purview of the notification. Secondly, my lord, even if suppose, my lord, presuming that I am not within the purview, when there is a notification of the state of West Bengal, when the finance minister of the state of West Bengal is claiming that I am exempt from tax, then, my lord, how, my lord, it can be alleged at all that I have committed a fraud or I have intent to evade tax and all that. My lord, those criteria of section 75, they do not apply at all to me. And they should not have waited. They just want to keep the money with them. 5.5 crore they have collected. So they waited till the last. To the extent they could have waited, they waited. And then after 4 years, they have issued the so-called notice to me, different mill owners. And, my lord, the difficulty, another issue is that there was one more writ petition which we had filed before the single bench. After the writ petition was filed, they have dropped the demand with respect to the another mill owner who is similarly situated. And the concerned assistant commissioner or the concerned proper officer has given a categorical finding that the value should be less than 25%. There are at least 3 to 4, my lord, authority for advance ruling, my lord, and which they have accepted. Because, my lord, from time to time, the authority for advance ruling, wherein, my lord, the joint commissioner of the state tax, joint commissioner of the central tax sits as a member. It is, I'm not saying that it is binding, it creates a binding precedent because the law does not say so. But if they do not agree, if the department as a department do not agree to that authority for advance ruling, they should have appealed against it. They should have taken it further if their allegation is so that that all the mill owners have committed a fraud, then they should have taken it in the appeal. But they have accepted that authority for advance ruling order, and recently also they have passed such. So advance ruling authority is following its precedent. From time to time they are passing order. Even the authority concerned has dropped, my lord, the proceeding in case of another mill owner, given a very categorical speaking order, dropping the entire demand. So, my lord, I am similarly situated also, and I have already paid 5.5 crore rupees, which is lying with them since 4.5 years. So that, my lord, needs to be refunded, my lord. But may I please, my lord, a supplementary affidavit, another, my lord, case where they have dropped the proceeding, my lord.
All right. What is the prayer in the writ petition?
All right, the prayer, my lord, kindly refer to page 35, my lord, of the, no, sorry.
Page 97.
Page 97, 98.
97, 98, my lord.
Order, quash the order in original, stay the order in prohibition, declaring the providing service of job work in the nature of so-and-so is exempt from the levy of GST, serial number 3A.
But those, my lord, prayers, my lord, there are alternate prayers. But I don't want your lordship to go through all those prayers, because, my lord, we had challenged the validity of this notification. Why we had challenged 3A, my lord, in case we fail, all my roads are blocked and I fail. Then, my lord, we had challenged only as a matter of last resort this notification 3A, because my lord, as per the GST Act, my lord, in the concept of composite supply, if suppose I am bundling two supplies together, then section 8 very categorically says that you have to consider which is the principal supply, and the ancillary supply will merge into the principal supply. Here there is no dispute that I am doing the job work on behalf of the state government. So my principal supply is the job work. Rest, my lord, my this nutrient and this supply of bag, because obviously if I am doing the job work, converting the wheat into the flour, then I have to give it back to the government. So the bag only I am purchasing. So these are all incidental to my principal activity. And the notification, my lord, carves out a distinction. There is a entry 3, there is a entry 3A. Entry 3 says that if the value of the goods exceed 25%, then it will be outside the purview of 3, and it puts me into 3A, which says that if the value is more than 25%, then I totally go out of it. So my submission is, my lord, that this to consider to create a distinction between a good supply or supply of goods or services, my lord. This concept of composite supply which they are bringing into the rate notification, that is not permissible in law. The law says that either it has to be treated as one supply. So my submission is, my lord, that once I am doing the job work is deemed to be service as per Schedule 2 of the, my lord, the GST Act. And once it is a service, then, my lord, this artificial distinction cannot be made. 25%, more than 25, less than 25, this distinction is not permissible, my lord. There is a Supreme Court judgment also in the case of Mohit Mineral, which says that this concept of composite supply is only for the purpose so that this artificial distinction is not done.
So where is that 3A?
My lord, I will, my lord, hand over, my lord, that notification to your lordship.
It's not annexed here.
The notification is not annexed.
No, that was one of your prayers. You should have annexed that notification.
Well, it should have been annexed, but my lord, at that time, my lord,
Serial number 3 and 3A, 6A of Schedule 2.
But this do copy nahi hai.
See, if your case is, you will fall under 3. Why have you to challenge 3A?
अरे central दो ना पहले.
If your case on facts, there is no dispute, it is less than 25% according to you, accepted by the state government.
Yes.
Where is the occasion to challenge 3A? There is becomes totally superfluous.
Well, I am not pressing that also. I am not pressing that challenge. That was as a matter of admission. I am not going to go into all those disputes.
How does the adjudicating authority get over the stand taken by the state government?
Well, I am kindly refer to
page 102.
Page, my lord, kindly refer to page 134 of the, my lord, the petition, my lord, stay petition. Page 134. The key disputes to be resolved in this case, my lord, 18.8.
Volume 1. Then where is volume 1?
Key disputes, my lord, kindly refer to page 134.
Oh. One and 2 is not there. Page 1 to 180.
No, 134, my lord, para 18.8.
Volume 1 and 1 and 2 is there. 3 and 4 is not there. Totally, there are 4 volumes.
Correct.
I have got 1 and 2. Ladyship has got 3 and 4.
Correct, my lord. I don't know what is the issue. We must have filed 2 petitions. It cannot be like it will not be accepted by the registry.
That's correct.
Shall I hand over an extra copy I have?
Let them search. Give them 5 minutes.
3 and 4. 1 and 2 भी दो ना. तो दो.
3 and 4. Okay.
So 1 and 2 Malad.
1 and 2 you please give.
1 and 2. 1 and 2.
Now it's page 134.
134 Malad. Volume 1. Whether the contractual agreed value of goods rupees 60 as per the agreement between the noticee and an FS department can be considered the actual value of the goods supply within the composite supply valued at 260.48. And second, whether the noticee qualifies for exemption under serial entry 3A of the notification number 12/2017 as amended based on the valuation and percentage of the goods component in the goods. So only the dispute is the valuation and percentage of the goods involved. That is the only dispute they framed, my lord. Kindly refer to the value of the goods which is on page 133, my lord. Page 133. Undisputed facts, records of the case. We are also not disputing this. This is undisputed, my lord. Receipt of wheat and charges. The noticee receives 100 kg of wheat from FNS department and the following consideration was paid by the FNS department per 100 kg of wheat. Monetary consideration for 100 kg of wheat. So this part is monetary. Crushing charge 90.78. Packing charges 50. Fortification charges, addition of vitamins and nutrients 10 rupees. Transportation charges 28.70. So total 179.48 is a monetary consideration. Now what is non-monetary consideration? Retention of byproducts. 4 kg of bran they are allowing me to retain, which is priced at 80 rupees. 1 kg of refractors 1 rupees. So 81 rupees. So total consideration 260.48. This is undisputed, my lord. Now, my lord, kindly come to, my lord, their investigation regarding cost of the goods, my lord. That is on page, my lord, 108. During salary result, my lord, para 6.4. Para 6.4. During course of investigation by DGGI headquarters, the value of goods supplied, that is the goods material used for fortification, packing material etc., that are procured by the flour mill from the open market were examined. Upon scrutiny of evidence and gathered in various cases, it has been ascertained that the value of goods involved in composite supply, that is fortification material and packing materials, have been found to be in the range of rupees 81 to rupees 130.23 approx per quintal of wheat. The breakup of value of the goods supplied in such is brought out as under the cost of premixes. But I am not reading out any further. They are saying that 81 to 123 rupees should be the per quintal value. Now, my lord, kindly again go back to my lord page. But their finding analysis 1, my lord, page 135. Page 135, paragraph 8.9, my lord. Value of supply of goods in the composite supply.
No, it is all tied, no? You give 1 and 2 there, 3 and 4. 1 and 2 to leadership you give. You return this 1 and 2. This one you return. You return. Yes. You are returning that. Returned with thanks. It has been categorically clarified.
It has been categorically clarified in last sentence of para 3.1 of circular number so and so that whether the value of goods any composite supply exceeds 25 requires assessment on a case-to-case basis. From the expression requires assessment on a case-to-case basis, it becomes crystal clear that the value of goods to be considered shall be the actual value of the goods in each case and not any prefixed presumptive value differing from the actual real value of such goods supplied in the composite supply. So that is their assumption. The circular does not say so, they are presuming. That is their interpretation. Furthermore, it is well-established principle of statutory interpretation that unless a specific meaning is explicitly assigned to a term in a statute, the words or expression must be understood in their common parlance. In the case of entry serial number 3A of the impugned notification, no particular specific meaning has been assigned to the term value. Therefore, the term value as used in the entry serial number 3A of the notification number so and so as amended must be considered as the actual value as commonly understood and not any prefixed or contractual value. It is a matter of common reasoning that the actual value of supply of goods cannot reasonably be less than the cost incurred in procuring those goods. But this actual value cannot be less than cost. That is not what the law says. Kindly refer to section 15, my lord, for a moment, my lord, if your lordship permits, my lord. Section 15.
No, how do they come to this conclusion?
My lord, I'm reading out then, my lord. Upon detailed examination, I find that the actual cost of the inputs in question, namely packaging material and materials used for fortification, have been meticulously calculated and elaborated in para number 6 of the impugned so-called notice under the heading value of goods in composite supply. This calculation revealed that the actual values of packaging material and nutrients are significantly higher than the contractual value of 60 as claimed by the noticee. Moreover, the actual values when considered as part of the composite supply exceed 20% of the value of composite supply as follows. Cost of pouch, cost of nutrients, total cost of inputs 81, 91, 103, 123. So they lower end, higher end, they have determined the value.
No, where from they got this material?
They have, in that is why I showed that particular paragraph, my lord. Paragraph 6.4, my lord. Sorry, no. Yes, paragraph 6.4, page, my lord, 108. 108, my lord. During the course of investigation by DGGI headquarters, the value of goods supplied, goods material used for fortification, packing material, etc. that are procured by the flour mill from open market were examined. Upon scrutiny of evidences gathered in various cases, so since all the mill owners were examined, from where they procured the data, we have no idea, my lord. It has been ascertained that the value of goods involved in the composite supply, that is fortification material and packing material, has been found to be in the range of rupees so and so per quintal of wheat. The breakup of the said value of the is brought out as under. They brought it out.
Was the assessee called upon to produce invoices?
Yes, they were called upon to produce invoices.
So you have produced invoices to justify your price at 60.
But
I'm sorry.
Yes.
At 50. Let us.
That varies from time to time. The cost of any item, my lord, whether fortification item or this, they are not uniform throughout the year. So, my lord, we are not into what was the cost, because it was.
They made a search, etc., collected some information.
Correct.
Went to the market, ascertained the value.
Correct.
And they say it is between the range of 82 to 123.
Correct.
But as an assessee, you can produce your invoices to show, let us assume the market price is 110.
Right.
You have been procuring from a particular supplier throughout the year. And let us say 1 ton or something of packing material you are getting. Nutrients also you are getting in bulk. So you can always justify your costing.
Well, I will have to refer to the reply about what they submitted regarding the cost.
Now you are against refusal to grant interim order.
Yes.
Yes, my lord.
You have already recovered 5.5 crores.
No, Lordship kindly sees what the order has been passed by the Honorable First Court. Lordship kindly sees, because the Honorable First Court has recorded that there is a disputed question of facts involved, and going through the scope of the order which they have challenged, that's the final order. So therefore, my lord, they had the alternative remedy also in their hand, which they have not availed. They have come to the Reed Court straightway, and they have challenged the final order. Therefore, there is no scope for any interim order as such in the facts of the present
suppose
case.
if you initiate, apart from that, they also seek for a writ of declaration to declare a particular provision as ultra vires section 8.
Yes.
That is, that one prayer is also there.
No, not section 8, only entry 3A to the extent it excludes that composite supply.
Composite supply.
And Honorable Court has only said that
See, can you sit in judgment over the decision of the state government? State government is the person who grants the exemption. You are nobody in the scene. See, what you do is, he is the revenue collector. And in terms of the GST law, it has to be distributed on a percentage basis. He comes to the conclusion, this particular type of service or whatever job work he does, if it falls within a particular parameter, it is exempt. Unless and until you find that particular notification itself is perverse.
Or he is claiming reference to other cases on the ground that they are similarly situated. Or in the show
No,
cause.
that is one other point. But our question is, if the state government certifies that he is entitled to an exemption under a state notification, can you sit in judgment over it? You may have paramateria power. You may be, that is, the state is duty bound to share the revenue equally with the central. But still, if the state says this service is exempt, it can be also a measure to have the price at a controlled rate. Some of it may go to the open market, some of them will be as PDS items distributed through the ration shops. So to peg down the price, to keep it at par, the government says, all right, this will be the average cost. Because he is the person who enters the job work, correct? State entity, any state entity which procures paddy, procures wheat and gives it to you to convert it, crush it into flour, add some nutrients so that it reaches the end customer. Some may sell it in the open market, some may sell it, or no, you are supposed
No, this is through PDS system.
This
is distributed only through PDS.
Therefore, the object behind such issuance of such notification is in the larger public interest. Otherwise, what happens is, you can always go to a shop or any marketplace and take the invoices, sample invoices. Obviously, the cost will be more. So that issue is there, whether you can sit in judgment over their decision. And who's to implement, who's to find, who's to ascertain whether he falls within the notification or not. It is not the central authority, it's a state authority, because it is their notification. See, virtually what you are trying to do is negate the effect of the notification by having a roving inquiry in the market and having your own study saying that the price will range anywhere between 86 to 123, and therefore we cannot take the transaction value submitted by the assessee. But this transaction value has been accepted by the state government, exemption has been granted. Are you trying to sit in judgment over that decision? Can you do it is the question. You confront the assessee, probably in a search operation or as a survey, get hold of invoices saying that there is an undervaluation done, actual value paid is so much and so much, but he doesn't stand to gain.
Well, they are not disputing that I have received more than 260 rupees. That is what they are not disputing at all.
So therefore,
they are saying that the cost has to be replaced by the actual value given by the state to me.
How do you say? See, we procure in bulk, but to purchase a single item, obviously the cost will be more. Similarly, source of procurement. Suppose, let us say, there is a, I don't know here whether cooperative societies are into polypropylene bag making,
yes,
jute bags, or mixture of both. There are a lot of other societies which do only this, hand woven and machine stitched to be supplied for a particular department. Suppose he is able to identify a supplier who's ready to give him a 40% discount. How do you say that presumptive value has to be obtained and the real transaction value, which has been accepted by the state authority, has to be substituted?
Also, in that case, allow us to
Also,
file
my lord,
affidavit
section
at the order
74 could not have been invoked in any case. It is an issue of interpretation. Whether this or that is correct, whether the state is correct or center is, section 74 could not have been invoked, my lord.
Let us file
In any which case, my lord.
Sir, WBGST, GST Act.
My lordship has passed so many judgments that when the issue involves the, my lord, the classification or an interpretation of law, then my lord, 74 is not invocable.
Non-monetary consideration আমাদের বক্তব্য
Where is the question of suppression of fact?
Lordship, whatever points has fallen from me, Lordship, kindly allow us some time.
But kindly allow me to
Let us consider these
take
points
the,
and
my lord,
come back, Lordship, and we'll satisfy your Lordship.
the, my lord,
Or
kindly
in,
allow me
in the
to take
alternative, Lordship, kindly allow us short time to file our affidavit in opposition, because since the first court has also allowed us to file the affidavit in the meantime.
But did you canvass this point?
Yes, my lord.
See, virtually by virtue of their exercise, the exemption granted by the state government has been made nugatory.
Yes, madam.
You should have questioned the jurisdiction.
That question is there, my lord. The
This
issue of
point was
jurisdiction.
subject to correction was never taken.
No, no, my lord. This issue of
There should be material to disbelief. See, you can't paint
no, no, we have taken all those points, my lord. In our grounds, if your lordship wants, I can read through those grounds. We have taken those grounds. They could not have substituted their opinion about the, my lord, the cost.
You can do it assessee specific. See, let us assume like you say that movement of goods not proved. What do? You ask him to produce all the lorry receipts. Then you make investigation, Vahan app. Some of them are Toto, some of them auto rickshaw, some of them are three-wheeler, other things. Some of them are private cars. Then you say you are not proved. So you be assessee specific. You seize material from him and say this value, but that you don't dispute.
But they are not disputing, my lord, that I have received 260. Had they made an allegation that I have received more than 260 rupees.
Yes.
Say I have received surreptitiously, my lord, maybe 300 rupees. If their allegation was that this extra, they are,
according to them, the transaction value of 60 rupees
should be at least cost. That is what they say in the order it is written.
Transaction value, which you say at 60, is less than the procurement value.
That is what they are saying, and they are saying that the transaction value cannot be less than cost. That is what saying. That is not what the law says, my lord. Law does not say. It says that the price paid or payable in respect of a transaction, provided the buyer and seller are not related. If there is a relationship, then my lord, I go to the rule. But if there is no relationship between the buyer and seller, and unless they have any ground to challenge that I have received some cash flow which is in addition to that, my lord, maybe I have indirectly received some consideration from the state government through some other means with respect to this transaction, then they could have.
No, this is all based on assumption, I think, saying that commercial activities are inherently profit driven. Consistent undervaluation would suggest either a non-commercial motive or a deviation. How do you doubt this transaction between the state and the assessee?
My lord, they have
That
not.
moment,
They have.
my lord,
They have
so,
never.
my lord,
They have
my
never
lord,
doubted the method of calculation.
Kindly refer to, my lord, the state finance minister letter, the principal secretary letter, notification, and my lord, the commercial tax, my lord, the state tax department has issued a notification.
Are the facts of the
But
advance
despite
ruling
that,
in
they
other
are
cases
saying that
different from the facts of the instant case. Therefore, the advance ruling in other cases which were forwarded by the authority will not apply.
they are all the same. I can show that.
No, my lord. We have clearly stated that.
I will show, my lord, from the record, the order itself, that it is the same. The allegations are same. Everything is the same. The order which has been passed in one of the meal case after we filed the writ petition, that fact is also the same. The so-called notice is identically worded in all the cases. Well, it is the Central Tax Authority which has dropped the proceeding in another matter. I will show that. After filing of the writ, that order has been passed.
Since virus has been challenged, Lordship, kindly give us an
I am not
opportunity to
going
file the
into the
affidavit.
virus, my lord. I am not going into
And
the
even
virus.
whatever they have stated, my lord, we need to dispute it.
My lord, I am not going into the virus, my lord.
If you see the state government notification at page 147, there's a lot of restrictions. What an empanel floor mill, what an empanel floor mill to do certain acts with the prior consent of the state government, application for selection.
But the entire meal is under their control, my lord, the state government's control. It's a very strict agreement. I cannot even act for other. Well,
Yes,
privately,
there's
I cannot do
a
anything.
clear prohibition. Clause 4 of the notification, subclause 2.
What is apparent is not real. What is apparent is not real. Instruction. We need to take instruction.
So on these points, my lord, we need further instruction from our from the department also.
And this matter is pending since very long, my lord.
Wait,
Now,
sir,
what
wait,
instruction, my learned, the authority cannot give any instruction which is not part of the order, my lord. Everything is there in the order. Whatever is the reason, they have disclosed it. But agreement is on page 156 onward, which is in the similar line as the, my lord, as per the notification.
Packaging also, there is a particular stipulation. What it should contain, and all flour mills shall use different colored printing of labeling or fortified atta packets for different months as specified to the state government. Obligation of the mill. Very, very detailed notification, sir. And this is that exemption.
Page 170 also regarding price also there is a notification.
Yes, page
170, Malik. The price which I will receive.
Now, virtually, by virtue of the order and original, you have set aside the notification dated 7th of September 2018. You have superseded the notification. With what material? No material from the assessee, but by a general search, your own research, you went to the market, you went there, etc., etc. So then you do one thing, you file your affidavit in opposition. The remaining money you don't recover. There will be a stay of recovery. Whatever has been paid, let it be treated as a deposit.
5.5 crore. There is a Supreme Court judgment now also, my lord, Radhika Agarwal.
Or we can do one thing, file a statutory appeal. We will ask them to 10%. 10% of the amount will be adjusted as against the pre-deposit. The remaining will be refunded to you.
That way I will take instruction, my lord. I'll take instruction and come back on the next week.
That will be better.
That can be done, my lord. I mean,
That is correct.
correct.
You don't retain the money.
Then they have to give up the virus point in that case.
No, I will give the
No,
double
he
point.
won't. He will argue all points.
with
He will add some more points
with judgments.
from what fell from the court. No jurisdictions.
But section 74, my
70, there is no question of suppression of fact, extended period and all, not apply.
on that point itself,
Where is the intent to evade payment of duty?
Also, kindly gives us a short
Kindly,
time
my
to
lord,
file our
my
affidavit. We shall
humble
come back
submission,
and
my lord,
we
is-
shall place our
No,
case
my lord.
as
No,
the
my lord.
version that
No, my lord.
we feel.
My lord, this, whether
Without
this
affidavits, my lord,
74 is, my lord, it does not require, my lord, any affidavit. My lord. On 74
but-
only, my lord,
On
the,
74, it can go. It will
my
go.
lord, the petition can be decided. my lord. On 74, my lord. I'm not saying, my lord, that to enter into.
And you have used those two words. That's it. Suppression. That's all.
Page 144.
74 73.
Where is the show cause notice?
My lord, so cause notice is on page, my lord, 509. Volume 3, my lord.
Please show which paragraph they say why they are invoking 74.
Yes.
507.
To show cause.
No, page.
Procedure.
514.
थोड़ा শেষের দিকে থাকছে
74, my lord, the invocation is on page 535, my lord. 535. Section 74 has been reproduced. Then, my lord, paragraph 13.1 onwards is there. My lord, allegation 538, my lord, page 538. In terms of, shall I read out, my lord, paragraph 13.1? In terms of explanation 2 of section 74, the expression suppression will mean non-declaration of facts or information which a taxable person is required to declare in GSTR returns under the GST Act. But in the instant case, the taxpayer is declared transaction value of the at rupees going through
non-monetary
data of state price value of the by way of the pricing
Straight
transaction
away we
value
can
of
question.
Well,
In
non-monetary
terms of
consideration.
Lordship kindly once comes to page 80, 134, the table.
134.
And my show cause. Also page 538.
134.
134
Lordship kindly comes to 134. Your Lordship will find the table at the top. Below the table, Lordship kindly sees out of the 100 kg wheat provided, the noticee returned 95 kg of packaged and fortified atta to the FNS department, keeping with them 2 gunny bags valued at rupees 43, 4 kgs bran valued at rupees 80, and 1 kg refractors valued at rupee 1. So these are the non-monetary considerations.
This is not disputed, my lord. This is not
You
disputed.
are not disputing this
Sir,
at all.
these were never disclosed. Now, Lordship,
My lord, 260
now,
rupees, my lord.
now Lordship
There-
kindly
there's
sees,
no
now Lordship kindly sees
non-disclosure.
536.
No, that is clear, sir. It is here.
My lord, kindly see on the above only, my lord, this page 133 onwards. Page 130.
Please see page 170.
170.
Ones with pricing.
Less cost of 2 gunny bags, 43. There is no suppression at all, sir. What you say is, that's what I read, not just a well-established principle. Oh no, sorry. Commercial activities are inherently profit-driven, and consistent undervaluation of goods suggests either a non-commercial motive or a deviation from standard. You are forgetting about the particular notification issued by the state government in 2017, which requires him to be empaneled. He is put on very strict terms. He is an exclusive supplier for the state government. Why? Because they want it at a particular rate with a particular fortification and ensure that the supplies are made good. Several conditions are there. So there is no question to doubt then you are doubting the state government. 74 cannot be. You get instruction. We have
The alternative, in the alternative, Lordship, can you allow us
adjourn
the
it. We allow.
time to file affidavit?
Section 74, my lord, can be decided without affidavit. The issue of section
Get
is
instruction, whatever you want you do. We have heard we have elaborately heard the so and so. Mainly no, after we have heard the submissions and perused the material papers which are placed on records, prima facie we are of the view that two issues would arise for consideration. Firstly, whether the provisions of Section 74 of the WBGST/CGST Act 2017 could have been invoked, and whether a case has been made out for suppression of facts to evade payment of tax. On going through the show cause notice and the order in original, prima facie we find that this is not made out. The second issue, which appears to have not been elaborately dealt with by the adjudicating authority, is the effect of the notification issued by the state government of West Bengal, dated Government of West Bengal Food and Supplies Department, dated 6 September 2017, called as the West Bengal Public Distribution System, bracket open, empanelment of flour mill and milling of fortified atta / whole meat atta, bracket close, guidelines 2017. On going through the said guidelines, page 147, we find that several conditions have been imposed upon the flour mills, more particularly that upon empanelment, they are prohibited from indulging in private milling for commercial purpose except with the prior written consent of the state government. What would be the effect of such notification? Can the said notification be overridden by the central tax authorities, or the transaction be doubted when the state government is satisfied that the supplier, namely the appellant, is entitled to the benefit of the notification? Apart from that, what is the entitlement of the empanel flour mill, such as the petitioner has also been stipulated by notifications issued by the Food and Supplies Department, Government of West Bengal, from time to time, and the latest notification appears to have been issued on 7/9/2018 regarding revision of price structure for distribution of fortified atta for AAY beneficiaries. There is no dispute as regards the price structure, which has been admitted by the adjudicating authority in paragraph 18.7 of the order of adjudication. In such circumstances, the question would be whether upon certain investigation and inquiry conducted, mostly without notice to the appellant writ petitioner, can the transaction value be doubted by the central tax authorities in the absence of any specific allegation of any fraud committed by the appellant writ petitioner? It is submitted by the learned advocate for the appellant writ petitioner that out of compulsion, the appellant writ petitioner was compelled to pay more than 4.5 crores,
more than 5
crores, as against the impugned demand of more than rupees 8 crores, of more than rupees 8.73 crores. The appellant writ petitioner has also sought for a declaratory relief in the writ petition, and considering these facts, the learned single bench rightly directed the respondents to file their affidavit in opposition. In addition to the grounds which have been canvassed in the writ petition, two of the issues which have been pointed out in the preceding paragraphs would also arise for consideration apart from other grounds that may be placed before the court. Therefore, we are of the view that no further recovery should be made from the petitioner, and the recovery proceedings for the balance amount shall remain stayed. An option is a suggestion is made to the appellant writ petitioner as well as to the department by permitting the appellant writ petitioner to file a statutory appeal before the appellate authority, subject to the condition that 10% of the disputed tax amount be retained towards the disputed liability, towards the for the pre-deposit to be made before at the time of filing the appeal, but the remaining amount which has been recovered from the writ petitioner should be refunded. On this suggestion, the court will hear the submissions of the learned advocate for the appellant writ petitioner as well as the learned senior standing counsel for the respondent department. Let us see. 74 it will go.
And I did not hear, my lord, the last part.
What will happen is, you do this, he will supply substandard goods, and the people of the state will suffer. People of the state, you are hitting them below the belt.
Several meals have been closed, my lord. Several meals have closed.
You drive down that side, right from Birbhum, this side, and you go towards Murshidabad. Either entire things are paddy fields, and you have huge mills. Many of them have shut down, and you are going to shut down the remaining also. Thanks to all the efforts taken.
In 2020, my lord, during the peak pandemic, they called DGGI has an office here. We requested that we'll participate in the proceeding here. They said, no, you have to come.
You should have filed a writ petition. You sat tight, then what?
We filed several writ petitions on behalf of other petitioners, my lord. So there, wherever.
Sir, I had one more line, sir. The learned advocate appearing for the appellant submitted that in identical circumstances, the adjudicating authority himself has dropped the proceedings initiated in show cause notices issued to other flour mills. Apart from that, there are decisions of the advance ruling authorities on the very issue in favor of the assessee. This aspect is seriously disputed by the learned senior standing counsel.
Part of the
he is disputing it.
Yes.
Disputed by the learned senior standing counsel appearing for the respondent department. The court will hear the submissions on the next hearing date. State government, you have to say something, sir.
My lord, I am appearing for the state.
Oh, we have to say something.
Well, we have already.
They are virtually tearing up your notification, and you are sitting and watching.
Well, this has been explained.
No, you should have agitated it at the right time. When these fellows are transported to Delhi and been harassed, you should have come to their rescue. And what rate are you paying them? It is impossible. See, because throughout the year they will get job work. That's the reason they are staying with you. If you don't support them, merely issue a notification and go get yourself drowned, you should support them. See, virtually he has set aside your notification. What is the object, sir? This is something like a control order. Under the Essential Commodities Act, control orders can be passed as well as guidelines can be issued. This is in effect a control order. And his entire activities is regulated. I don't say Mr. Vinay Sharaf's client is a holy cow, but presumed to be holy cow, because the regulations are so stringent. If he violates, they'll take action. And whether they pay him or not is another question. That is more important. No? Everything is said and pen on paper, whether it is realized into, probably you will get it once in 3 years, something. it keeps trickling. And you also keep on crushing, sending it. Many mills have shut down, my lord. After this, my lord, this investigation have been launched. So if you stop payment, you don't release it, then the third shift he will operate for outside. You can't control, sir. You have traveled that side, no? You have gone to Birbhum. You cannot enter from the national highway. How to enter the rice mill is very difficult to find the route, especially after 6 p.m. So night shift he will operate for other milling agents. You don't pay. If you don't pay, we don't know whether they are being paid. You know, from what little I can say is there will be definitely, probably on a monthly basis, something will trickle. This is harassment. And if you do this, he is bound to cheat. Suppression cannot be collective unless and until you prove abatement, conspiracy. Do you mean to say all these, I think 4 or 5 districts have got the maximum number of these rice mills? Do you mean to say they are all so united to join together and cheat the government? No, they can't. Each fellow is fighting for. And very recently, Honorable Chief Minister opened up another, we saw in the newspaper, one big advertisement, milling, ultra modern, this, blah, blah. That was on Saturday, I think. No, Mr. Sharaf is doing pro bono.
That
Hard
he
to
never
be.
said. That he
Hard
never
to-
said.
5 matters in a week is one journalist demolished.
My lord,
He starts from minimum of 500 pages. Meaning, one journalist demolished.
My lord, whether I'm doing
it's a compliment or otherwise.
No, my lord, I don't know what, I could not hear him.
No, he says 5 matters of yours, one jungle is demolished. All trees will be cut down because so much of paper. And he is using soft copies.
That's why 2
that is
copies
what
are
so
missing right now. This to us. He can show this to us.
Next.
Grateful to your
My
lordship.
lord, your lordship is, my lord,
Covid hache
kept
Covid.
it for which date, my lord, your lordship is?
Which date? 18 September.
No,
But 18th
before that.
September, your lordship. We don't want to.
We'll
My
keep
lord,
it
this
some-
month, my lord, by the,
We will give Mr. Day also some time.
yes, my lord,
After 2 weeks, man.
after 2 weeks.
You give some date under the same caption. Next.
After 2 weeks.
Grateful to your lordship.
Grateful.
Item number 3.
Yes, sir.
I'm appealing for the respondent numbers 1, 2, and 3.
Who are the others?
Others are private respondents, my
Pro
lord.
forma.
They are the benamdars and the beneficial owners.
What was the writ petition?
Well,
What
the writ-
happened to your writ petition?
Yeah, slightly interesting facts, Millard. I am the owner of a property, Millard, which is sought to be, Millard, transferred in the name of one of the Benamidars, what they say, Millard. And there was an agreement, although unregistered, agreement for sale. Part consideration was paid, 1 crore 90 lakhs. That is the pith and substance of the basic issue, Millard. Now, Millard, there were notices of provisional attachment notices under section 24 of the Benamidar Act, Millard, that was served where I was made a party. I was copied. And Millard, thereafter, Millard, there was an order of provisional attachment. The period of provisional attachment, I will take your lordship to the act and the letter and spirit of the sections enunciated in the act, Millard. The period of provisional attachment to initiate, after that, the initiation of section 26, the period is 90 days. I never got a notice. Although the property that is sought to be, So far as 26 is concerned, my lord, I never got a notice, my lord. Till 24, I was aware. Now, my lord, 26 happened, my lord. Hearing was given. I was never made a party. The property which is sought to be, my lord, transferred in favor of the Benamidar, alleged Benamidar or Benamidar, I'm not on that at all, my lord. It was my property. It is recorded even in the orders that the property description is mine. So, my lord, I would rather fall in the category of an interested party, my lord. That is, my lord, under section 26, 1C, my lord. I was never made. Thereafter, my lord, after the 26 procedure is over, my lord, comes section 27, my lord. Confiscation. Confiscation happens and that notice comes to me, my lord. And there was an order of deposit of the money part consideration which I have received, my lord. I preferred a writ petition. My shortest point, my lord, is
sorry for interrupting.
yes, my lord.
You challenge the order of confiscation. No.
No, I challenge. Yes, I did. Because prior to that, my lord, I did not have any occasion to, my lord, represent myself, which is otherwise a mandate under the act itself, under section 26. I never got that opportunity, my lord. So I challenge that order, my lord. The learned trial court, my lord, directed, my lord, deposit of the money, my lord, without calling for affidavits, my lord, on the first day itself.
Which money?
The amount that I, my lord, received as part consideration.
That already attachment is there.
Yes, but I have received the money. The money is with me. But there's a provisional attachment, my
Then
lord.
you can't run away with the money.
I'm not running away with the money. That is gone. Provisional attachment stage is gone. 26 happened thereafter.
26 happened. In
27 happened thereafter.
And those 26, 27, you are not party.
I was not a party, my lord. Even in the order, my lord, it would be abundantly clear, my lord. We actually, my lord, then we'll, my lord, got in touch with the buyer, purchaser, who is allegedly the Benamidar. They supplied me a copy after we filed the appeal, my lord. We got a copy of the order, my lord.
What was the occasion to direct you to deposit 1 crore 90 lakhs?
Well, that what they say is that this transaction is a prohibited transaction under the act, my lord. Sunima,
No, transaction between the petitioner and the proposed purchaser. No.
Yes.
That's a prohibited transaction.
Yes, that's what they say.
And that fallout is on account of the 27 order.
Yes, precisely, my lord. Precisely, my lord.
But then, if he is not a party, how will he appeal against that order?
May I?
Let him finish, my lord. Then
May I show a few portions from the writ petition, my lord? That will kindly take, my lord. First, my lord.
Now, the learned judge has directed you to deposit the money.
Yes.
As a result of which, what benefit will accrue to you?
Nothing, my lord. Lords will kindly see, my lord. Lords will kindly see the impugned order once, my lord.
Page 91, my lord.
Page 91 of my state petition, my lord. Lords will kindly see, my lord. Paragraph 5, my lord. What submission was made on behalf of the income tax authorities, my lord, Mr. Sharma, learned advocate, appearing for the respondents, submits that the petitioner was all along aware of the entirety of the proceeding. There is no challenge to the order of 21st of March 2025 by the respondent number 4. Now, my lord, a submission has been made, my lord. Nothing from the order I could find that they could have produced one contemporaneous document showing my knowledge with regard to the proceeding under 26.
So, for that, the learned judge has directed affidavit to be filed?
No. Kindly see, my lord, the last part of the order, my lord. In view thereof, I direct the writ petitioner to deposit the entire amount, confiscated and notified for surrender by communication dated such and such, with the Registrar General, same shall be invested, etc., my lord. Paragraph 7 at page 93, my lord. No affidavits were called for, my lord. This is my primary grievance, my lord. Even if I, my lord,
Please show the order which was impugned in the writ petition.
yes, yes,
Notice has been challenged. Notice under section 29.
Page.
yes, my
Page,
lord.
my lord,
Page
62.
62, my lord. Lord will kindly see.
Sir, the prohibition of Benami transaction. Page 63.
62, my lord.
62. My lord,
May I hand over a book, my lord? I
Yes,
can.
sir.
I have a soft copy here, so I can just.
The book is available. Page 63.
62, my lord. First annexure of my appeal, my lord.
And what
Which is
the-
again in turn the first annexure of the writ petition, my lord. Lord will kindly take the top corner, my lord. To Startec Infra Developers Private Limited, my lord. That is us, my lord. Lord will kindly see the list, my lord. Date is 30th of June 2025, my lord. This is the notice under this is the confiscation order. This is the order we challenged. No, Lord will kindly see subject notice for surrendering / delivering possession of confiscated property under section 29(2)(a) of the prohibition of Benami property
All right,
transaction.
we'll pause. Mr. Sharma, this is an order passed under 29(2)(a). Notice issued under 29(2)(a), asking him to return this 1 crore 90 lakhs. According to him, he had no notice of proceedings at the stage of 25,
26 and 27.
and 27.
Yes, sir. Because that was not required.
Pardon?
That was not required. He is nobody.
He is nobody.
He is nobody. My humble respectful submission, my lord.
No, this is a query from court. So you please answer. See, by directing him to pay this money to you,
my lord,
what remains in the writ petition?
My lord, this money,
It's as good as he had dismissed the writ petition.
After the order,
What we can do is 190 he has, received as advance, which according to you has to be is already under confiscation proceedings. He has to return it. He will maintain it in an escrow account.
Well, but the honorable single judge has directed that the amount to be kept with the registrar of.
No. Why? He will retain it with him. He will retain it with him. The court will examine whether he was a party to the proceedings under the Act. If he is a party, you establish he was a party. He was put on notice. He did not, or you argue that nothing need to be given to him.
My lord, he was not required to be made a party.
He
is, my lord, the foundation of the.
May I place section 26 once, my lord, for the convenience of the court, also for of my convenience, my lord. Lord will kindly take section 26. It's the longest section, my lord. I would like to place it in its entirety, my lord. Adjudication of Benami property. On receipt of reference under subsection 5 of section 24, that's the provisional attachment, my lord. The adjudicating authority shall issue notice to furnish such documents, particulars, or evidence as is considered necessary on the date to be specified therein on the following persons, namely: A. The person specified as Benamidar therein. B. Any person referred to as the beneficial owner therein or identified as such. C. Any interested parties, including a banking company. D. Any person who has made a claim in respect of the property. So it's my property. And they have issued a 24.
No, see,
they have
without an affidavit, we cannot decide the matter.
Yes, my lord. Yes, my
what
lord.
you do is, you retain the money in yourself.
Deeply obliged, my lord.
And you, instead of Registrar General can't do anything.
Yes, my lord.
With this money, unnecessary problem. You open a separate escrow account.
Yes, my lord. Fair enough.
In which you specify an officer of the department who will be a signatory to the account. This will be maintained in an escrow account, interest bearing. You file within 3 weeks. You file a affidavit in opposition. The writ petition will be heard out.
Well, that's fine. Here, my lord, what is happening? I have to make one submission, my lord. But the writ petitioner is trying to cloud everything. He is nobody, my lord.
We are able to see that.
My lord, why, my lord? I will show one document. The entire foundation will collapse. Here, the foundation is agreement for sale.
Another thing is, my lord, the confiscation or the attachment would not be given effect to unless, my lord, the compliance of section 26 are
That has
concluded.
to
my
be
lord.
decided, sir. Or we can do one thing. You invest it in a fixed deposit, surrender the deposit receipt to the
Fair enough,
department,
we can do that, my
and
lord.
My lord, one thing,
it will abide by the decision of the.
Fair enough,
That will
my
be
lord.
best.
my lord, as per section 27, as soon as order of confiscation is made, the property becomes property of central government.
Exactly.
Section 27, subsection 3. Now, at this moment, that property is property of central government. Order of adjudication by the adjudicating authority has not been challenged by anybody. Neither the Benamdar.
Says he is not party. He is not. Put
He
on
was
notice.
not required to make a party because, my lord, as per his the writ petitioner's own version, whether by submitting, my lord, the entire foundation, the claim of the writ petitioner is agreement for sale. That the writ petitioner had entered into an agreement for sale with the Sunima, who is the Benamdar, and in pursuance of that agreement, the writ petitioner has received a sum of rupees 1 crore 90 lakhs as an advance for selling a property. During the proceeding under section 24, my lord, the writ petitioner had submitted a reply stating that that agreement has been cancelled. So now the writ petitioner is trying to thwart the due process of law by this writ petition. My lord, may I place that document?
What is your answer for this? He says that agreement stands cancelled.
It's a statement of the written writ petition, my lord. My lord, kindly come to the paragraph 7 and 8. Second page, my lord.
So it's gone.
Well, then I will come back with instructions because I was not aware of.
No, if this is the stand taken by the chartered accountant of the petitioner, then your entire case falls.
And this is
Yes, my lord. That is why, my lord, will kindly adjourn this. I will take instructions and come
Tuesday.
back. my lord.
Tuesday.
Tuesday, next
And
Tuesday.
not only that, my lord, even Sunima is saying that Sunima means the
All
Benamdar.
right. We have heard the learned senior advocate appealing for the appellant. You give that also.
My lord,
And Mr. Amit Sharma, learned standing counsel for the department. The petitioner has aggrieved by, the appellant is aggrieved by an interim direction issued by the learned report, directing the appellant to deposit a sum of rupees 1 crore 90 lakhs with the learned Registrar General of this court, the direction to invest the same in a short-term fixed deposit with any nationalized bank, yielding highest rate of interest, and shall keep the same renewing until further orders in the writ petition. The order impugned in the writ petition is a notice for surrendering / delivering confiscated property under section 29 within bracket 2 within bracket small a of the Prohibition of Benami Properties Transaction Act 1988 within bracket the act. The case of the petitioner, among other things, is that they had no notice of any other proceedings, more particularly proceedings under section 26 and 27 of the act, and they received the notice for surrendering. They received the notice under section 29 within bracket 2 within bracket small a of the act. Therefore, it is submitted that the condition imposed by the learned single bench is onerous and the same calls for interference. The learned senior standing counsel appearing for the respondent department submitted that the theory as proposed that the appellant writ petitioner need not be issued any notice as they are not required to be considered as any entity in respect of the proceedings initiated under the 1988 Act. Furthermore, it is the stand of the writ petitioner themselves, as could be seen by the letter given by the chartered accountant dated 23/2/2021 to the initiating officer, Benami Provision Unit, that the agreement with Sunima Steel Marketing Private Limited has been cancelled. So further, it is submitted that Sunima Steel Marketing Private Limited has given a letter to the appellant petitioner dated 18 June 2020, stating that they agreed to cancel the agreement for sale and requested the appellant petitioner to refund the earnest money of rupees 1 crore 90 lakhs. The learned senior advocate appearing for the appellant requests time to get necessary. Learned advocate appearing for the appellant petitioner requests time to get instruction from their client. List next Tuesday.
Deeply obliged, my lord. I will also take instructions with regard to this, my lord, because I would never make a submission which is not right, my lord.
Next.
Deeply obliged, my lord.
Well, I'm appearing for the respondent High Court administration being led by Mr. Siddhartha Banerjee. Mr. Banerjee is not present today in Calcutta.
No, we wanted you to give some written.
Yes, my lord, as the documents are with Mr. Banerjee and Mr. Banerjee is the panel lawyer, your lordship.
That is correct. You could have taken
I
a
don't-
copy from the Registrar General and produced.
I am not in the panel, so my lord, I am not the privy to the documents. But I'm
Senior has been waiting from the morning.
I conveyed it to him, my lord. I'm
Sir, please
really
give.
apologize.
No, my lord, if I may, my lord, assist your lordship, my lord, I am representing the London district judge. My lord, your lordship's observations I communicated to the London district judge. And I wanted him, why you have not assigned reasons, it's just a order, unreasoned order. Now, my lord, he has given me in writing something. But if your lordship wants, my lord, I can.
You just hand it over.
Lordship, yes, I can. I'll have to then, my lord.
You don't give it to Mr. Bhattacharjee now.
For the time being, my lord, no,
Don't give, no.
Lordship kindly peruses this. My lord, briefly speaking, my lord, this is not in service. He is not in service since 2007 September. So, question of unauthorized absence for a person who is not in employment. That's the.
But after the accident, did he make an attempt to join duty?
Yes, I'm grateful to my lords.
Where is that?
To my lord that I immediately on.
See, if he had made an attempt to join duty or willingness to join,
Yes.
not allowed to join, and order was passed, that order was challenged and writ petition set aside. Correct? Which is the
Now,
joining.
Milord, just a second, Milord. Your lordship may kindly permit me, Milord, to.
Paragraph. The registration paragraph 9 of the modified.
Just 1 second, Milord. And we see that the accident took place. This accident, Milord,
the order carries.
Article.
Is that letter?
Page 99.
90.
999.
99.
99. একটু বলবি তো আমাকে
Sir, he has sought for extraordinary leave, sir. Sir, we will do one thing. We will send it back to the district judge. Let him take note of all these factors. That the employee agreed to join, also sought for extraordinary leave. If the fact that the accident prevented him from joining or prevented him to discharge his normal duties, that needs to be considered. Secondly, on the date of when he went on leave, how many years of service he had completed?
How many years, Milord? Just I.
Ask him whether his service was regularized.
Lord, if I may, my lord, if I may, my lordship may kindly have a look to my lord, your lordship's order, violation of which has been complained of. My lord, your lordship, my lord, this paragraph 10 of the order, the liberty which has been granted to the writ petitioner in paragraph 9 of the impugned order is slightly modified by observing that it will be open to the appellant to submit a representation to the disciplinary authority district judge for appropriate orders regarding the period of unauthorized absence, and if done so, the same shall be considered in accordance with law.
We will reiterate the same thing. We will add one paragraph regarding this man's request to join duty made on 10/12.
That's what I'm trying to show to your lordship, my lord. If your lordship kindly comes to my lord internal page 4 of the order under appeal, which was paragraph 9, which was modified. Lordship kindly see the case that was made out. Paragraph 9, I am placing of the honorable single judge, which was modified by your lordship in the.
That is the order passed
Let
by the
me finish. Paragraph 9, my lord, lordship kindly.
Page number?
But internal page 4, running page 17. Internal page 4. Paragraph 9 was modified by your lordship.
Yes.
Lordship, kindly may I place. It is submitted by the learned advocate for the petitioner that the petitioner was not allowed to join his service.
Right.
Such a dispute was not canvassed by the petitioner in the date petition. Therefore, that is no longer open to him.
But then on facts at page 99, it is available, sir. That he has made a request. Let him consider, was his service regularized?
Service regularized at that point of time. Milord, on instructions, I'm submitting that at that point of time. Milord, and I say something, just one line. The order which my lords had passed, many of my colleagues said, after looking into the order, that the extreme, rather, I should say, the
generosity,
the benedictions impelled with the sympathetic consideration by the division bench. Milord, this order I cannot, Milord, say anything more. But even then, Milord,
even here in the High Court,
yes,
fellows don't report for duty. In fact, I've passed very on the administrative side, I've removed them from service, compulsory retirement, etc. But certain cases, he has mended his ways. And the registrar concerned has also said for past 2 years, he is working properly. So we have slightly modified so that at least he should feel the pinch. So that small pinch you give, he'll be another 5 years of service is there. He'll be ready. We will send it back. Let the district judge take it.
Kindly give some because
what is passing the lordship's mind? Your lordship is sympathetic to this gentleman.
No, not sympathetic.
But then,
we should be.
Lordship kindly sees the prayer was rejected by the in 2007 itself. That prayer was made.
So, in fact, paragraph 9 of the order we modified. So, therefore, the finding rendered by the single judge is gone. This contempt application has been filed, alleging willful disobedience of the order and direction in FMA number 208 of 2025, dated 11/3/2025. They said that an appeal arose out of an order passed in a writ petition in WPA 8454 of 2009. Substantial part of the finding rendered by the learned single bench was affirmed, and we found that there is no reason to interfere with the order passed by the learned single bench. However, the observations/findings rendered by the learned single bench in paragraph 9 of the order passed in the writ petition dated 12/11/2024 was modified to the following effect. Please quote para 10 of our order in FMA. Thus, the finding rendered in paragraph 9 of the order passed by the single bench stands substituted by the above reasons. If that is so, then the learned district judge was required to pass appropriate orders on a representation which was directed to be submitted by the appellant writ petitioner. The appellant writ petitioner submitted the representation, but however, the representation was rejected on the ground that the learned district judge has no authority within the ambit of law to allow the representation made by the appellant writ petitioner. In our view, though it is alleged that the respondent has committed a contempt, we are of the view that the action initiated by the learned district judge cannot be construed to be a willful disobedience so as to be construed as committing a contempt. Therefore, to that extent, we do not agree with the applicant slash writ petitioner. Be that as it may, we are of the view that appropriate revised orders should be passed by the learned single bench by taking note of all factors which have been pleaded, including the fact that the writ petitioner, submitted a representation on 10th of December 2007, which is found at page 99 of the annexures in the contempt application, addressed to the learned Additional Chief Judicial Magistrate, Jhargram. The subject in the said letter is inverted comma prayer for grant of leave. In the reference column, the communication of the learned Additional Chief Judicial Magistrate by a order number 189 dated 26/11/2007 has been referred to. The applicant writ petitioner would state that he faced a bus accident on 12/9/2007 while he was going to attend his official duties, and after he attended, and on the next day, that is, However, on and from 14/9/2007, he could not attend office duty due to severe back pain, and he was examined by the orthopedician at Midnapur town, and thereafter he proceeded to Cuttack to get treatment under one Dr. T. Rao on 27/9/2007, and according to the advice of both the doctors, he was compelled to take bed rest. Further, the applicant writ petitioner will state that he has brought this fact to the notice of his office, and he is not in a position to stand and walk, and as the doctor has advised him to take bed rest. In these circumstances, the applicant writ petitioner requested to be excused for his absence from duty by granting either special disability leave in terms of clause 3Is of Rule 196 or extraordinary leave in terms of Rule 175 under West Bengal Service Rules Part 1. Photocopies of the medical prescription and the medical unfitness certificate were also enclosed with the representation. This appears to have not been properly appreciated by the department while taking a decision which order was impugned in the writ petition. In any event, since we are of the view that the learned district judge should pass fresh orders, and while doing so, the learned district judge shall also take into consideration the request made by the writ petitioner by his representation dated 10/12/2007.
Milord, I made a representation also on 11th of March 2008 to permit me to join at page 102.
Requesting either for grant of either special disability leave or extraordinary leave. Page
102. 102.
Even thereafter, another representation has been made to the learned district judge on 11/3/2008 for grant of permission to join in service after leave, wherein it has been stated that he was not permitted to join duty by the learned Additional Chief Judicial Magistrate Jhargram without the permission of the learned district judge, and therefore prayed for appropriate orders from the learned district judge. These factors shall be borne in mind, and the learned district judge shall also consider as to whether the services of the applicant writ petitioner was regularized much earlier, and take a holistic approach of the entire matter and pass fresh orders um, um, as expeditiously as possible, preferably within a period of 4 weeks from the date of receipt of the server.
I'm
copy.
extremely
4 weeks.
It's lie. This is a blatant lie. Giving the next 13 times, recommend blatant lie. He did not join.
No. He says he met with an accident on 12/9. 13/9 he went to the office. So ladyship says it's a blatant lie.
Blatant lie. He didn't join. Basically, it is clear.
14/9
Didn't
and then bus accident, etc. Let us see what happens.
Well, I have no words. I say with the greatest of respect that what my lords have given. Yes, I say, my lord, nothing. I cannot get anything an inch.
All right.
There is already a breaking
Let us see.
surface.
This stands disposed of, my lord, this contempt.
With the above direction, contempt application stands
Grateful.
disposed of or discharged. Let us see.
This paper is whether it will be a pick on.
No, sir.
This has to be returned.
We will return this district judge paper. Both copies you return. Saturday we allowed one. So therefore, because we told what is his name? Choraria.
Tomorrow and Thursday. My lord, difficulty he will be alone. My lord, I have one matter of Mr. Sharaf where I have to be there. But he wants cross-examination of 39 transporter.
39
transporter in a transaction. But he has filed an appeal. But he told me that tomorrow matter. I have told him I'll not be there. He will be also praying for adjournment for next week.
No, where are you going to cross-examine?
My lord, he wants cross-examination of 39 transporters.
Oh, before the single bench.
Before the authorities concerned, GST authorities. Not be there. I want to be there. Well, next week.
Then you have to increase your number of people who will do tax.
My lord, next 2 weeks, my lord, next 2 weeks, the bench is not there. So I'll be free. I'll be here all the day.
No, you increase, I say.
We are trying to, my lord. It's a new setup. Suddenly, my lord, a new setup. We are trying to, my lord. And I'm also getting some opportunities to do matters by itself.
Yes, you come to the division bench single matter, then wherever suppose it is distributed, irrespective of classification, you send 2 other government lawyers.
Yes, my lord. I'll try to, my lord. My lord, if tomorrow, if he doesn't come, my lord, kindly adjourn for tomorrow.
Advance adjournment. All new procedure unique for High Court at Calcutta.
Yes. It's a request, my lord. It's a my lord, only before my lord we can make this type of requests. Lord, honestly, my lordship, this is the.
No, Saturday we told him. In fact, Saturday we had work up till 3:45.
I saw him. He was the only person.
Only person here.